Now we are on, and all the stuff I just said was, hi, I'm Karen, this is Bobby, Steve's over there, and we're gonna do Title IX training. So all the other introductory stuff I said for the last minute, I guess doesn't really matter. We are recording today's webinar, and so you will be able to access that recording on our website, and we'll leave that up indefinitely. We'll also have copies of the regulations on the website, copies of the slide deck, which you should have already received. We made a couple tweaks, and Steve said he found some typos last night, so blame Steve for the typos if he found them. But all that will be on the website in a recording form, as well as stuff that you can download. When we do the recordings, I post it as one long 3-hour chunk, and then I also try to chunk it up by topic so that if you remember, oh shoot, I wanted to know about XYZ, you can just go to that topic. And I'm curious if that's useful to you all, because we want to make sure that these webinars are good. We crave your feedback. So if you find that useful, let us know. If you find that to be not useful, let us know. One of the things I like about doing webinars is that you all can be in the comfy, cozy area of your office or at home and not have to be out on the roads and coming to see us. One of the things I don't like is it's really hard for us to know if we're connecting with you or not. And so we really do want you to text us questions, comments, concerns. This is Steve's cell phone number today. He's going to be handling, collecting the text messages and then asking us the questions. But you can text all along. You don't have to wait for a formal break. You can text and then we'll answer as they come. But we also will have specific times that we take breaks. Last thing, if you're watching on Zoom and you've got like a Hollywood Squares situation happening, if you want to see that, that's great. If you don't want to see that, you can slide down and pin the video of us. And the way you do that is you run your mouse down to where you see the video of us and highlight that little square. On the upper right-hand corner, there's 3 little dots. Click on that and you can select pin video. If you want to see the slides and us side by side, which is what I would want to see if I was watching it, you can go up to the top of your screen where it says screen sharing. There's a little thing that says view. Click on that, and if you pull it down, there's an option to select side-by-side view, and that would get you the slides and the video side-by-side on your screen. If that doesn't make sense to you, someday maybe I'll do like a little webcast on how to do that. But so that's the last little housekeeping thing. Okay, so my job for the next few minutes is to give you the basic overview of Title IX. Most of you know a lot of this stuff, but in order for this to be qualified training for Title IX coordinators with the Office of Civil Rights, we have to do some of this initial dancing. One of the things you're going to hear us refer to over and over again is OCR. If you don't know, and don't feel bad, a lot of people don't, the Office for Civil Rights is an arm of the U.S. Department of Education. They are charged with making sure that every educational institution that receives federal funding complies with all the federal anti-discrimination laws. Title IX, Section 504, the prohibition against discrimination on the basis of race that's found in Title VI and other places. And so when the Office for Civil Rights comes calling, by definition, they're saying, if we don't like what you're doing, we have the ability to withhold your federal funds. Now, OCR hasn't done that except in one instance. They withheld a portion of federal funding from Chicago Public Schools last year, but they don't willy-nilly withhold your federal funding. But one of the reasons you're going to hear us talk about the Office for Civil Rights and our concern about OCR investigations for the next 3 hours is they're pretty aggressive in telling schools what they want schools to do, because they know that they swing this enormous stick. We're probably going to do whatever they ask us to do. So that's OCR. OCR has different offices across the country. We are the Kansas City region, which is actually good news because they are a region that's pretty good to work with. We have really good relationships with most of the OCR investigators that get assigned to come to Nebraska schools. But the problem is we can kiss up to them all we want. It's the higher ups in OCR that have sort of set the policy direction for how they're going to enforce these statutes. So with that said, Title IX is a federal statute that prohibits discrimination on the basis of sex. If you have the slides printed out, I always circle sex because as we talk, it's going to get farther and farther from like what the heck is sex. We had a long conversation last night about like locker room, if girls are misbehaving or boys are misbehaving in the locker room, is that on the basis of sex? Is the fact that they are sex segregated into locker rooms make everything that happens in a locker room automatically a Title IX problem? There are people at OCR that would say yes. The same thing goes for whether or not you're gay, whether or not you've had sex, whether or not you're pregnant. All of that stuff to me didn't initially flow from the idea of sex. To me, sex was, you can't have this job because you're a girl. But the definition of sex, as the federal regulations have interpreted it, is way broader than just biological sex. So no discrimination on the basis of sex in any education program or activity. Programs make sense. You cannot tell a girl that she's not allowed to take math. Activities is much broader, which includes sports, which most of us have figured out, but it also includes things like the summer trip that the band takes to go to band camp to learn how to do the choreography for marching band, and a whole bunch of stuff that doesn't touch as directly on the school as you might think. And then the last thing is federal financial assistance. Everybody listening today is a public school, so y'all get a ton of federal financial assistance in the form of special ed, even if it's not as much as they promised us, school lunch, title funds. There's really no way for us to say that we don't receive federal financial assistance if you're a public school. So what is discrimination on the basis of sex? The regulations say it's anybody that gets treated differently based on the person's sex. Notice that first bullet point. I don't want people to think that if you have to do a Title IX investigation or if a school has Title IX issues, that doesn't mean that you're inherently a sexist or a misogynist. It doesn't require any particular hostility or intent. A simple difference, inadvertent difference in treatment is enough. There's a great case from Bobby's alma mater, where a boy wrote in his yearbook that his hobbies were Netflix and chill, which, if you are not up to speed on all the Urban Dictionary slang, basically is like, come over and have casual sex. The boy wrote that in his yearbook biography. A year or two later, a girl wrote that in her yearbook biography. The principal of Bobby's old school says, I didn't know what it meant when the boy wrote it, but I know what it means now that the girl wrote it, and so he told the girl that that was not okay. Huge Title IX lawsuit, because the girl is saying boy was permitted to say that, she was not. And this subpoint is what's gonna really hurt the principal, I think, in Bobby's school case, because the fact that he wasn't intending to treat the girl differently because she was a girl may not be enough to get them out from under Title IX liability. Next bullet point, it includes sexual misconduct. You've probably heard all the news about the new regulations and the rape culture on campus and how some young men on college campuses think they're being railroaded by false allegations of sex assault. And you're saying to yourself, sex assault is a crime. Why is this a Title IX issue? That's because sex assault, sexual aggression, sexual misconduct all falls under that broad definition of on the basis of sex. It definitely includes gender stereotyping. If you're saying to yourself, man, Karen sounds like a bitch, that is gender sex stereotyping. It also may be true, but it's stereotyping. And so that's obvious. Sexual orientation and gender identity is probably included in the definition of sex. The reason we say probably is, you know, sexual orientation is not specifically a protected class under Title VII. And in Nebraska, we have a constitutional amendment that specifically says we are not permitted to treat sexual orientation as a protected class. But if the way they get there under Title IX is they say, if you assume that women only have sexual attraction to men, you are sexually stereotyping women. So it's not that we're protecting gayness, it's that we're protecting non-stereotypical definitions of sexual attraction. And then gender identity, we'll talk about transgender later, and you'll be sick of it by the time we're done. Some of the key terms under Title IX that you're gonna wanna be able to fling around as you do Title IX investigations. Unwelcome conduct is something that can be done by an employee or a student. Most people understand that. It also includes third parties. So if you're doing a construction project at school and the construction crew is catcalling girls as they walk into the building, that's a Title IX problem for you, even though you don't employ the people that are working on the construction project. Of a sexual nature, which includes sexual advances. It includes the creepy teacher that sleeps with girls that we're going to talk about, the creepy female teacher that creeps on boys, also included. Includes both nonverbal and physical contact of a sexual nature, whether it's consensual or not. If the person who is being contacted, the person in the one down position of the relationship, somehow feels compelled to be engaged in that relationship. And then it includes non-sexual gender-based conduct like calling somebody a bitch or a whore, hostility based on sex or gender. This is the idea that rape and other forms of sexual violence are a Title IX problem. Again, sex harassment is more than having a pinup girl calendar in the shop. It includes things that are actual crimes under the Nebraska Criminal Code. And so all of this is included. One of the big mistakes schools make is when there's an allegation of sex assault, they call the cops and call it good. What we're going to tell you today is you do have to call the cops, but then you have to launch your own independent Title IX investigation, because Title IX sex discrimination includes sexual violence. Throughout this deck, and hopefully you got the slides yesterday or Thursday when we sent them out, Friday when we sent them out, and you've printed them or had a chance to look at them, you'll notice at various times throughout the deck, the type is in green. Anything in green is going to be in reference to new regulations that have been promulgated and proposed by the Obama administration and the Education Department and the Education Secretary, Betsy DeVos. So what's happened when Trump was elected, one of their policy focuses was to make sure that people accused of sex assault had adequate due process before they were punished in some way in an educational context, separate and apart from a criminal context. So in 2007, Betsy DeVos said, we're going to stop, and you guys will remember all of those Dear Colleague letters that came out during the Obama administration, and we were constantly scrambling to figure out like what the new enforcement protocol was under this or that Dear Colleague letter. Whatever you think of the Trump administration or the Betsy DeVos portion of the Trump administration, I like, as a school lawyer, that they have decided that they are not going to make rules just simply by sending out a letter anymore. And so she announced this change in policy in 2017. And as part of this, they rescinded a whole bunch of old guidance that had been in existence under the Obama administration. I think this is the 4th year that we've done this statewide Title IX training. A lot of the old decks that I went through as I was looking to get ready to put this deck together, a lot of those old decks include guidance and advice based on letters and rules that are now rescinded. So anything that refers to a Dear Colleague letter other than the one in 2001 and 2014?
2001.
14 was rescinded. Anyway, so I mean, all of the stuff that we've talked about over the years, the special focus on pregnancy, the special focus on girls of color that were struggling academically. I mean, as you've heard me talk about these issues over the years, all of those Dear Colleague letters are now gone, like they never happened. And so the green stuff will be what they're proposing that is now new. The black stuff is what is the law, and we don't reference or rely on any of those rescinded letters and any of the stuff we put together for you today. This is now right after Betsy DeVos said we're not going to make rules based on letters. They released a letter that is a question and answer document about on-campus sexual misconduct. This 2017 letter was in effect when we did last year's Title IX webinar. So if you heard me talk last year about this, that's still good stuff. And some of the guidance or advice that we're going to give you today is based on this Q&A letter. This is something that if you receive an allegation of sex assault, you should probably be familiar with or know to go download this to keep an eye on it as you do that investigation. So the most important thing that came out of that September 2017 question and answer is the Department of Education from DC now says every school district has to make 2 choices in what they're going to do on Title IX issues. First, the board has to decide whether you're going to say we're only going to punish kids for alleged sex assault if the evidence is clear and convincing, or we're only going to punish kids if the evidence is a preponderance of the evidence. I'm going to explain what those 2 things mean, and then I'm going to explain why this is kind of a false choice. So clear and convincing is if you think of it in football analogies, beyond a reasonable doubt, I think of as you got into the red zone on the football field. Clear and convincing is you're in field goal range, right? You're about the 30-yard line. It's a heavier burden. Preponderance of the evidence just means you crossed midfield. You got to the 51st yard line or the 49th yard line, however you're thinking about it. So you have to decide how much evidence you're going to need to decide that somebody actually has violated Title IX if you're going to punish a kid. The problem is the guidance also says that they expect schools to use the same standard, clear and convincing versus preponderance, for all of your disciplinary rules. So if you say to yourself, or if the board says, we want to make super certain that before anybody is punished for sex assault, we have clear and convincing evidence. We want that higher standard. That means that before you can punish somebody for juuling, you also have to have clear and convincing evidence. What they say is it has to be the same standard for all disciplinary things. Most schools just use the preponderance of the evidence. Hey, you touched her, get on the wall, no more recess for you. That's enough, right? We don't have to have clear and convincing evidence. And so if that's the standard that you want for other disciplinary decisions, that's the standard that you have to use for Title IX. So we offered this to policy service subscribers, this choice last year, and every single one of our subscribers selected preponderance that I'm aware. I don't know of anybody that's selected clear and convincing because of the implications it has for your regular student discipline. So that's the first choice you have to make. What's your evidentiary standard, clear and convincing or preponderance? The second choice that you have to make is, are you going to allow people to appeal decisions of discipline based on Title IX allegations? And if you let one side appeal, you have to let the other side appeal. And again, most schools already have a little process that you can go up and tell the superintendent did something wrong, and then the Student Discipline Act allows you to ultimately go to the board. And so allowing those procedures hasn't really been an issue for schools in Nebraska, but knowing that these choices exist will help you understand the new regulations a little bit. So on November 29th, 2018, the U.S. Department of Ed announced their new regulations. They were published in the Federal Register, and then they gave 60 days to interested parties to make comments. There are a ton of comments that have been submitted. KSB talked about submitting comments, and we finally decided that we were just going to be one voice that was sort of like background noise, and they wouldn't really care what we said, so we didn't. But that doesn't mean we don't have some real definite thoughts about these proposed regulations. The comment period is over, which means the Department of Education could say that these regulations are final any day now. They are not final yet, and based on the volume of comments, I really think there are a few things they're going to tweak, but I think their overall philosophical approach is probably going to stay the way it is. So although we can't tell you everything that you're going to have to know about the proposed regulations today, we're going to point out some issues that you're going to need to start thinking about. Now, assuming that these regulations get finalized yet this school year, we will do this Title IX webinar again next year since we have to do it annually, but we will do it early in the school year so that you can get trained up on the new regs once we know what those regs actually are. Are you wanting to say something?
Nope.
Okay. So if you are on Twitter, you saw yesterday that Karen Hassey's two legal worlds collided as Title IX and digital citizenship met in the middle of a Husker football. Maurice Washington is a football player for the University of Nebraska, starting wide receiver, or starting running back, and he is from California. He was alleged when he was in high school to have a video of his ex-girlfriend having sex with two of his peers. She says she was raped. They say it was consensual. Who knows? What is alleged about Maurice Washington, however, is that he had a copy of that video and that he sent a copy of that video to the girlfriend sort of to get back at her for breaking up with him. Now, the University of Nebraska yesterday released a statement that said, we are aware that this is happening. We don't think there's any other investigation that we need to do right now, but we're cooperating with law enforcement. Basically, it was a big nothing statement that they released. Question is, under the new regulations, would this be enough for the University of Nebraska to simply release a statement? And I'm not sure it is. 100%, I have no doubt that if another girl in Lincoln or California were to allege that Maurice Washington did something inappropriate towards her, whether that be dating violence, revenge porn, sending an inappropriate, dick pic, what Bobby calls junk mail, any of those allegations would be enough under the new regulations to trigger a mandatory complaint by the Title IX coordinator at UNL and a mandatory Title IX investigation that would have to happen at UNL at the same time the criminal case is going on in California. And these same rules now are going to apply with equal force to K-12 educational institutions.
I was just going to add a couple of quick things. Number one, I think he's actually facing indictment now. I think there's a warrant even out, or they've asked for a warrant to be able to bring him in and ask him about this stuff. So it's going to get interesting from that regard. I wanted to say, in Nebraska, we don't have what's considered a revenge porn law necessarily, but I believe there were 3 that were introduced this session, different versions of what would be considered revenge porn. This concept of, I have an image, whether I got the image directly or indirectly of this victim or person, and then I use that image to do something to get them, either to do something they don't want to do, to shame them, or for some other reason. If you read how California's law is set up, it's super broad. But even more than that, I think what people aren't necessarily considering, and why we like coming to schools and giving these presentations, is the possession on that phone on his phone for 2 years, even though he wasn't in the video.
Yes.
Is possession of child porn.
And that's the point I wanted to make,
Yes.
that it doesn't matter that there's a revenge porn statute in Nebraska or not. He's also being charged under the child pornography statutes. Those of you that have been in your school, or Bobby's been in your school, you've heard us talk about this to kids. And Maurice Washington is being charged exactly the same way that we talk about kids being charged in Nebraska for possession and distribution of child pornography, because having the video on his phone, he's in the active commission of a felony.
So one of the ways that we've been talking about this here, and we'll talk about it as we go through this, is, okay, so we get a call about a certain situation, or you read about a situation in the newspaper. How will this work under the new regulations? And so that's why we've titled it this way, and that's why we've sort of got the presentation set up. Here's what we've always known about Title IX, and here's what the new regulations would do. Because I think this is a perfect example of a case that if you're somebody who is thinking, okay, well, how will this be different? Or you have an experience this year of a girl that says, I sent this picture to my boyfriend 3 years ago. We broke up. I know he sent it to somebody else. If he sent that to 2 other people, there is a chance that you would have considered that one incident, right, to investigate. But under the new regulations, you, as the coordinator, might have to affirmatively file a complaint against that person because you've got 2 acts of it occurring.
Even if the girls in the picture say, I don't want you to. Right. And so that's like the new regs are kind of a nightmare. But even under the old regulations, I believe that you would be required to at least begin the investigatory process to see if there are Title IX implications to a sexting allegation going on. Those of you that I've worked with on sexting cases, you always hear me say, make a note on your calendar, 6 weeks from now, follow up with the victim. That's because Title IX requires that follow-up, whether under the old or the new regs. So your general duties under Title IX, when you have noticed that there's sex harassment or sex violence occurring, your duties spring into place. And that includes gossip, innuendo. I mean, you can't like be willfully blind to things that you're hearing about happening. Now, under the new regulations, one piece of, there's a lot of potentially good news in these regulations. You've probably heard in the media how horrible they are, and we're gonna certainly complain about a lot of aspects of it, but there are some good things about the new regulations, and this is one of them. The new regulations say that we are only going to hold schools accountable for violations of Title IX if the school district is deliberately indifferent to sex harassment and if it has actual knowledge of whatever is going on. The old OCR, the Obama OCR, had a standard that says knew or should have known. So even if you knew nothing about the dick pic that was making the rounds in the 8th grade class, if kids were giggling and somebody was crying in the bathroom and people were talking about, strange pictures going around, that may have been enough to trigger your obligation because you should have known. Now the deliberate indifference standard is you actually had knowledge and then chose not to take any action. So that is a change for the better under the proposed regulations. So once you receive this notice, once you know something is cooking, you must take prompt and effective action to end the misconduct, to prevent its reoccurrence. Quick footnote. Number 1, please notice that this is different than calling the cops, right? Calling the cops is punishing the misconduct. This is a whole different frame of reference. This is looking forward to say, we're gonna make sure this doesn't happen anymore and make sure it never happens again. The focus of the criminal justice system is punishment. The focus under Title IX is remediation and prevention of reoccurrence. In general, when you know something's going on, you have to conduct an investigation. The good news is, under the current statutory regulation system, that investigation is kind of like whatever you feel good about. The new regulations, that's where the big changes occur. And then you're also supposed to institute remedies as appropriate. You're supposed to also follow up with the victim to make sure he or she is not continuing to suffer a deprivation of educational benefit. The old guidance said 60 days. The letters that said 60 days have all been rescinded by Betsy DeVos, but OCR seems to still be expecting a prompt response that they define as within 60 days. You're never going to go wrong by hitting that 60-day benchmark. If you go beyond the 60 days, if it takes you more than 2 months to investigate, you better call your lawyer. I think you probably should call your lawyer earlier anyway, but if you're going to go beyond 60 days, you better have legal advice to make sure that you're still having a prompt investigation. Now, hopefully everybody that's listening to this webinar knows either if you are the Title IX coordinator, or if you're not, who the person in your school district is that's the Title IX coordinator. The regulations require every school district to designate one employee to be the Title IX coordinator. We had questions from ESUs several years ago about whether or not they could contract out to you to have somebody at the unit be your Title IX coordinator, which would be awesome, except you see the regulation specifically says it has to be an employee. So you can't contract that out to some third party. OCR wants the coordinator to have knowledge of policies and procedure, to be involved in the policy adoption or revision process, to receive annual training, whoop, whoop. And they recommend that the Title IX coordinator not be the superintendent. Now, this comes from a Dear Colleague letter that was rescinded, but I don't see any of these requirements changing except the last one. But with the new regulations, we had an email from Fred Hansen, who's a gunner and had already read the materials. We are not sure here internally if the new regulations go through as passed. I don't think you're gonna be able to have the superintendent be the Title IX coordinator anymore.
Well, that's one of our questions here. Okay, then in small schools, who traditionally has been the Title IX coordinator?
We have spent a lot of our time since November 28th and the new regs coming out, the proposed regs coming out, a lot of our time trying to figure this out. We will, once the regulations are finalized, we will have better, more firm advice. As I stand here today, I think your best bet is probably going to be, if you are a school that has one superintendent and 2 principals, I think your best bet is probably going to be that the elementary principal is the Title IX coordinator for the high school, and the high school principal is the Title IX coordinator for the elementary, and the superintendent sits over as the person who's able to make decisions in these investigations, and we'll show you that in just a second. I think that's going to be your best bet. Now, if you're in a school district where there's one superintendent, one principal, I think you're going to have to get your guidance counselor or somebody else trained up to do investigations. One of the things we're talking about is, and I think this is what we're going to do to try to help you if these rigs go through, I think we're actually going to hire somebody to work for KSB who can come in and do investigations for you on the cheap, because you don't want to pay lawyer, hourly rates for that. Because the way the investigation stuff is set up, the Title IX coordinator, I don't think can also do the investigation. And the superintendent can't be the Title IX coordinator or the investigator because he or she's the one that ultimately makes the discipline decision. So it's a mess. That's what we're telling you.
We have another question on that. Is there an issue with confidentiality or do a relationship issue with the counselor is the Title IX coordinator?
I don't have any problem with confidentiality or dual relationship if your guidance counselor is the Title IX coordinator. I have an issue with, does that person have appropriate training? Can that person really is a counselor used to doing student discipline investigations? There are guidance counselors in the state that I think would be excellent in that role. There are also guidance counselors in the state, I think, oh my gosh, he or she would be just not the right person for it. But yes, I think rolling the counselor into that administrative team of dealing with Title IX issues may be what a lot of schools have to do.
One of the interesting things that's going to come up in that regard, and we've got a case from the 8th Circuit from South Dakota actually that talks about this, is when you have actual knowledge as the school, and we'll talk about what that means, but there's a case that says when it involves teacher on student harassment, a guidance counselor cannot be the person that possesses actual knowledge, because the guidance counselor can't do anything to stop the misconduct in terms of punishing, redirecting,
Because he or she is
reassigning.
equal to the teacher
The
on
teacher.
the, yeah.
So even if we come up with a solution where we're going to use a guidance counselor, we're really gonna have to think through how that works. There could be collective bargaining implications. There could be all sorts of weird stuff, but you might have no other choice other than hiring somebody from outside or contracting with another administrator. If KSB hires like an investigator type to help all of you for cheaper, you might be stuck with one of those choices because it's not practically possible to make it your counselor. We're, again, still working.
You guys have heard me for the last 4 years saying, screw that, your superintendent can be your Title IX coordinator. I have fought hard for that because I understand that's the structure that makes the most sense under the new regs. We're trying, guys. We're trying really hard to make it work. I don't see how you, as a superintendent, can be the Title IX coordinator if the new regs go through as they're written. I don't see how that can possibly work. This is also from the 2015 Dear Colleague letter. See how I have an asterisk by job responsibilities? The assumption in all of this communication, whether it's from the DeVos Trump administration or from the Obama administration, Catherine Linehan when she was in charge of OCR, their assumption is that you have somebody whose office plate reads Karen Haase, Title IX coordinator. They assume that that's a full-time job. Now, what that looks like in Arthur County or Tri-County or, Pierce, they just don't seem to get it in terms of there are lots of schools out there where a full-time Title IX coordinator would spend most of their time playing solitaire. So this is what they expect the Title IX coordinator to do: coordinate compliance, including your procedures for investigating, and to identify proactively systemic problems that might be revealed by people coming. Like if people are constantly coming to you talking about getting their butt slapped in the locker room, that might be a systemic problem. So instead of just playing whack-a-mole and dealing with it as it comes up, you say, hey, what's going on in the locker rooms? Maybe we should have more supervision. Maybe we need to talk to the teams, whatever.
Let's go back to the investigation thing you were talking about there.
Yes.
So why can't the principal investigate even if they're not the coordinator?
Look at the administrative changes. This next slide is exactly what we're talking about. So the administrative changes require that a Title IX determination be determined by so an investigation has to be conducted and a conclusion made by an individual who is neither the Title IX coordinator or the investigator. So the way the regs have it set up is Title IX coordinator receives information that there's a Title IX problem. He or she creates a complaint or some kind of document that he or she then gives to an investigator who's not a superintendent, not the decision maker, not the Title IX coordinator. The investigator, whoever that is, goes and interviews everybody, reviews the documents. There's a whole bunch of stupid stuff that investigation has to do, including giving both parties, both kids, notice that they're going to be interviewed, letting them bring a representative with them to the interview. They have to be able to review your draft report as the investigator and review all the documents that you rely on, at least, I believe it's 10 days before the report is finalized. Then the investigator writes a report. This happened, here's my evidence, blah, 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 blah. Investigator then takes it, not to the Title IX coordinator, because remember, that's the person that started this whole process, takes it to the decision maker, who I think now has to be the principal or superintendent, and then that person decides whether or not the investigator's report is legit, and if so, what the consequences should be. So all of the administrative changes that they put together really presumes that there are 3 school people involved in every Title IX complaint: the coordinator, who reports to the investigator, who writes a report and gives it to the decision maker. And again, that's why our scheming, our best case scenario may be the 2 elementary principals cross investigating for each other, but that's why we're worried, because this whole process just is not consistent with how you have your school set up right now.
So that if they follow up, can the principal be the investigator?
The principal can be the investigator, but if you find that Cody did slap somebody's butt in the locker room, the principal then is going to be the one that imposes discipline on Cody. So that person is they're the investigator. What they're saying is it's called a single investigator model. Under the Student Discipline Act, the same person can get the complaint, investigate the complaint, enforce the punishment. And what the DeVos Education Department is saying, they believe the single investigator model is inherently unjust. And so they want a different person, they want it to look like criminal court, where a different person prosecutes, a different person investigates, and a different person is the judge. And that's the problem with this, everything we have in the state is predicated on the single investigator model. And the regulations as proposed reject the single investigator model, which means if you look at the next chunk, we're gonna have to train 3 groups of people now. We're gonna have to train your Title IX coordinator, which is you probably if you're listening. We're gonna have to train somebody to investigate, and we're gonna have to train a decision maker. That's why, I mean, yes, it's insanity. I get it. You're going, this isn't gonna work. Literally every call we get involving any kind of sex, anything, when we hang up the phone, we go in each other's office and say, holy crap, how are we gonna handle this under the new regs? Because the new regs presume an entirely different structure than we have. What were you gonna say?
Just that you said everything I was about to say.
Oh, okay.
All right, Bobby, before you get started on that, going back to the Mo Williams.
I've made you crazy. I realize that. Now I'm gonna make Bobby do the rest.
Yeah, we'll give her an over-under of about 2 minutes before she stands up again.
This is kind of related to the Williams. Are schools responsible for pictures that are being sent around outside of school during the summer break?
Yeah, good question. So are schools responsible for pictures that are being sent around during summer break, or the whole thing blows up over the weekend where the nude was shared on a Saturday night? And then even if we assume everybody has deleted it to try not to get in trouble, is that still a school issue? I think the short answer is absolutely yes. At a minimum, no, so we'll get to this in the investigation part, but keep separate in your mind for a little bit, and then we'll mash them all together in ways that make you crazy. The student discipline jurisdictional limitations and requirements compared to the Title IX requirements that you have both to the accused and to the victim with respect to the impact that that may have on both of them by their ability to access your educational programs and activities. So I think the short answer is yes, absolutely. Even if we have weird student discipline implications where we may have limitations not on school grounds, oh, look at that, less than a minute, not on school grounds, in a school vehicle, or in a school activity, you definitely are going to have school responses under Title IX.
So we had a Title IX issue last year, 2 years ago. It blurs together. 2 girls that don't go to school together are on a club dance team. And in the summer, they're in Iowa at a competition. Girl A surreptitiously films girl B in the shower and then sends that video out to all of their friends. Not a school activity, happened in the summertime. They don't even go to school together. But victim of the filming said that then she was, people said mean things about her and, you know, like thought she was like a slut and easy and whatever in school once school started. And then they filed a complaint based on Title IX. So, I mean, we could not have been less connected to school, and yet we got sucked into it. They ended up having to pay an attorney to deal with the family's complaints.
One more investigation question before you go. Can the SRO be the investigator instead of the dean of students?
Oh, so here's the problem. If you're going to have the SRO be the investigator, you've got a FERPA issue, because it's the SRO then would have to be your employee, which I think you could do because lots of times you pay half the SRO's salary, but then the SRO is not going to be able to redisclose whatever he or she discovers during the during the Title IX investigation to his or her cop buddies for the criminal. So the SRO could do school and only school, but they can't do double duty as school and cop. All right, go, Bobby.
Well, and that person also has to put together reports. So it's not that an SRO couldn't do it, but obviously what you're going to do in this case looks different than what you do for putting together a police report or some sort of standard response in that regard. So I think it's possible to take a lot of training. Okay, so we're going to cover a lot of this same stuff again, and hopefully about the next 20 minutes or so, and then we'll get ready for our first break. We have talked through a lot of it, but again, we're going to cover what Title IX has always said and what the new regulations say and kind of how that's going to work together. So anytime that you're starting your response to a complaint, so all the stuff Karen talked about, we understand somebody's in saddle as Title IX coordinator, as investigator currently to begin your investigative process. So step one is you have to stop any ongoing harassment, which typically means in most cases that you're going to have a discussion with the alleged harasser. You're going to start the student discipline process. You may suspend or expel that student. And as part of that is obviously a student discipline response, what's educationally appropriate, but then also being able to point to that as an action that is, one, shows we're not deliberately indifferent, but two, stops the ongoing harassment. So you've got to move quickly. You have to take steps necessary to ensure that it doesn't occur again. So even if it's an out-of-school, short-term out-of-school suspension, there are things you're putting in place, even when the student comes back, to make sure that it doesn't happen again. So dangerous words in these investigations. Some of these come straight out of experiences we've had. Some of them come straight out of lawsuits. These things aren't good. It's just teasing, no big deal. The people in our school would never do that. That doesn't happen here. I just can't believe that. Kids in our school don't send nude pictures to each other. I know he or she didn't mean anything like that. So imputing basically the intent of whatever the student said and trying to use that as a basis, either not to investigate or to avoid any consequences. You need to learn to handle these things. The workplace is difficult. In fact, I had a female teacher or a female principal say at one point, you know, part of me wants to tell her, young lady, I'm sorry, but part of this is, you know, I'm going to investigate, I'm going to help you out, but you need to get a little thicker skin. You shouldn't be in my office 8 to 10 times a day because something could be slightly offensive if you view it through the lens that this person's out to get you. So that sort of stuff really just doesn't have any place, especially in the Title IX side of it. If you won't file a written complaint, our hands are tied. That one in particular under the new regulations is going to go away, especially if you've got multiple occurrences involving the same alleged persecutor. When it is said, when it is a he said, she said, I can't do anything, that's one of the most common ones that we hear about. It gets back a little bit to what is going to be your standard of proof, right? If you pick a preponderance of the evidence, you probably do have an opinion on which one is more trustworthy. It's all hearsay. That's one that we get all the time. I don't care is the answer from courts, if it's hearsay, if it's not hearsay. At the point that that can be imputed to you as the school in terms of having actual knowledge, it doesn't matter that it's hearsay. It doesn't matter that it would be admissible in a civil court trial. It's something that can be a basis of knowledge for you. And this comes straight from some cases I think we'll talk about. Boys will be boys, kids will be kids. Everybody needs a thicker skin, that sort of stuff. These things, and the reason we put them in a standalone slide is because I don't care how awesome an investigation you did afterwards. They can show discrimination up front. In other words, if you say one of those things, if somebody hears you say that, it could taint the entire process. Okay, so during investigation, OCR requires interim measures. There are also requirements for interim measures as we talk about the new regulations, essentially the stuff that happens immediately that isn't necessarily student discipline, but is supportive measures for students. They're called in the new regs, and we'll hit on those a little bit. But again, provide the person who complained with periodic updates, minimize the burden on the parties to the complaint. So in other words, do a lot of the stuff yourself. Don't require them to interview or talk to anybody. Make sure the parties understand the process and keep them informed. Again, part of the new regulations, some of which is new, some of which is old, is making sure that you disseminate your policies and procedures on how this is going to work. So responding to harassment complaints, again, I'm not going to read down this list, but this is a good kind of step-by-step the way to think of it. I think too few people actually sketch out a plan. Oh, here she comes again. I'm just kidding. Sketch out a plan for their investigation. A lot of people say, all right, I'm just going to go grab kid number one. But I think if you put a plan together that includes who you're going to interview, the general gist of what you want to get from them, and then the documents and other things that you're going to review, that's a nice way for us to show that clearly you were not indifferent when you set out on this path, because you put some thought into how it was going to work based on what you knew at the time. Those things, those lists will obviously expand, and I think that's good, right? That's evidence that you remained responsive to what you found out.
That's exactly what I was going to say. The existence of this somewhere, a Google Doc, a Word doc, whatever, that you keep embroidering and sort of setting out your game plan is your best exhibit in protecting you from an allegation that you were deliberately indifferent. I have no doubt that you as a school administrator can figure out how to investigate misconduct and get to the right answer, but proving that you weren't indifferent is a different step. It's like, do the investigation, but also create proof that you were thoughtful in the investigation.
Yeah, it's a little self-justification, honestly, as you work through the process. The other thing that I really like about it is, number one, you'll be able to evidence things like that you met even OCR's recommended standard. And so you should check your policy. But to the extent that your policy doesn't say exactly how this is supposed to go, following the same process every single time is actually an act of legal significance. Because in the event mom has a bunch of notes that say crazy things that she alleges you or other kids said, if you can show that, no, I interviewed those kids, even if your notes aren't as perfect as we wish they were, being able to point to a typical and standard response mechanism is a benefit when we're doing things like weighing the credibility of evidence. Okay, so for the interviews, again, I think we could do, and we've talked about doing a whole standalone presentation on just how to do the interview process in and of itself, which is, as Karen pointed out, only step one of this three-step process in the new regulations. It's one of the last steps under the current structure, but essentially, once you think through the interviews, you have to interview at least the complainant and the alleged aggressor. All possible witnesses are important because obviously that's going to go to the weight of the evidence based on your legal standard. You need to remind the parties and witnesses that they're protected from retaliation. One of the things we hear all the time is, no, I don't want to file a complaint because I don't want that teacher, I don't want that kid's parents to retaliate against my son or daughter for having filed. I just want to talk to you about it. I don't actually want to file a complaint. Number one, in the new regs, that might not always be possible, and it might not be your choice as the parent, which is one of the interesting things that we'll talk about here in a bit. But to the extent that it involves another staff member or student, you've got to ensure and take steps to make sure that it doesn't happen, that anybody who reports it or serves as a witness cannot be retaliated against in the process. That's not going to change under the new regs. And then interview strategies. These are things that, again, I think with experience, and especially if you're in a smaller district, you know those kids. You know the right way to ask Johnny the question to get the answer you want versus Joey the same question. And you are entitled to rely on that expertise. But the concept being gather as much information as you can, start general, see what they'll say, and then hone in on the specific. That's just good interview investigative technique. Yeah.
Is creating a plan when you write down the people you interview and question, is that done by the investigator or by the coordinator?
Oh, that's a good question.
It depends, right? So right now, I think it is entirely possible that your superintendent is your Title IX coordinator, but that Title IX coordinator, to the extent they're involved, has functionally deferred to the principal through the student discipline process. So when you're sketching out a plan, it should be whoever is doing the investigation, right? There's no current requirement that the Title IX coordinator be the investigator. And under the new regulations, they literally specifically say the decision maker cannot be the same person as the Title IX coordinator or the investigator. So I think that the short answer is right now, it very well could be that even if you're the principal who's not the Title IX coordinator, but you're investigating, you're the one that should sketch it out. You should probably do it in conjunction with the superintendent to the extent that person is a coordinator. But as we move forward, it's going to be whoever does the interviews, because that person, in fact, arguably shouldn't be coordinating as much with the next two people in the chain because of how they want this single investigator model to kind of fall by the wayside. Yeah, and Karen's point is a good one, which is why the counselor is a little bit tricky because that's somebody who, if they're not doing it right or if they shirk their responsibilities, now the superintendent and the principal could be the ones that have to come in and impose discipline on that person, which makes them, especially if it's in the context of a Title IX investigation, look biased. It makes it difficult maybe even to pursue the personnel case in the same way that would. So the short answer, I think, is you're the one that needs to, if you're doing the investigation now or moving forward, you're the one that should put the plan together because you're the one that helps evidence in real time, not being deliberately indifferent.
Is it better to have students write down the responses or the investigator take the notes? Does it matter?
I don't know that it matters because what we're talking about is the weight of it, the credibility. What I care much more about is you as the person who puts together the report after you're done with the investigation, being able to articulate who you trusted, why you trusted. So if you think it would be better because that kid's weaseling is going to change his story, asking Johnny to write it down, but having a conversation with Sarah, who's one of your honor roll students, who's a confidant and taking notes, that doesn't diminish either of those things. But I think what it does, and I think the thing that you ought to think about is if you have a standard process, that's not a bad thing, but you're not legally required to have one. So I think I would say if you want things in writing, if it makes it easier for you to be able to point to as you're putting your report together, ask for it in writing. Oh, okay, sorry, I didn't know where. Okay, so now we're gonna get into some of these administrative changes that we've talked about a lot. This section that you'll see up here, 34 CFR 106.45, it is not an unmanageable read for all of you sitting out there to actually read through the new proposed regulations. In fact, I bet you could read through them, and other than stopping to pull your hair out or take a shot, you're probably going to be able to read them and know as you go through them, okay, I think I see exactly what they're talking about here, even though it makes me crazy. So if you were to read any of the stuff that they put out, this would be the one, this regulation that outlines the process. So we'll put it up on the website. But this concept that the school district bears the burden of proof, it's not either party that has to prove to you that they shouldn't be disciplined or that they were a victim. It's the school district that bears the responsibility, the two to three people in that chain of investigation under the new regulations that have to prove what actually happened. And so this concept of it seeming like a hearing or like a discipline process where to some extent, the other party bears responsibility to diminish the stuff that the other side is proving, that doesn't really apply here because it's the school district that has the obligation.
Bobby, can you start the investigation before you tell the parents so they can be part of the interview?
Can you start the investigation
before you tell the parents?
I think the answer is yes. I mean, there's no constitutional right for a parent to be present with a student in an interview at school. I don't know if that's exactly what the question is.
And I think in large part, you're gonna have to look at, you will have policies about interviewing students. Typically, it says if it's a school investigation, you don't contact the parents and you don't have to. Sometimes if you have somebody from the outside, like it's a police officer or something like that, sometimes you'll have a policy that says, yes, we will contact parents first. But typically, you would not contact parents first if we're talking about a school issue.
Right. Good question. And again, we get that question all the time outside of the Title IX context too. Okay, so back to these regulations. One of the things that you'll see moving throughout is this notion from the DeVos Department of Education of preventing the accused of getting railroaded by sort of the institutional inertia that can develop in some of these cases. And so we hit on that a little bit at the beginning, but if you think about that in concept as we talk through the requirements, what you'll see is a lot of trying to make sure that the tide rises both boats together. Even as we have to do more, the reason we're doing more in some cases is to equalize the opportunity for both the accused and the victim. And so both parties have to be allowed full participation, including introduction of evidence, which obviously could be inculpatory or exculpatory evidence throughout the process. You can't restrict the ability of either party to talk, which is really interesting as you go through the investigation, because you can, for example, if it's a senior boy and a senior girl, you could put one of the interim measures they talk about is a no contact order between the two. But then the regulations come back and say, but as part of, resolving their differences, informally, if the boy can talk to the girl and they work it out or they start dating again, well, maybe that makes everything better. So that's a little bit confusing, but that's one of the things they made specifically clear in the regs is the accused and the victim technically get to talk to each other about the process itself and about their involvement in the process. You must allow the parties to have the regulations talk about others present, whether you're thinking about that as a parent, as an advocate, as an actual lawyer that is hired by the family to represent their interests. Throughout this process, I think for the most part, and we'll hit on this a little bit as we go through the examples, but they're allowed to have others present. It's really awkward when you think about a K-12 school, what it means to have others present, because if you have a kindergarten victim, it makes a lot of sense. But if you have two seniors that want to self-advocate and one hires a lawyer and one doesn't, it starts to feel a little bit different. But just understand that the regulations don't say you treat a kindergartner any differently than a high schooler, right? They're entitled to the same type of representation. Allow sufficient time to prepare for interviews, and must either allow a live hearing that's required in the post-secondary context, or at a minimum questions and follow-up in writing, and we'll talk about how that plays out specifically.
And Deb, I think this goes back to your question. You can see how this is going to be problematic. Typically, you don't have to allow parents to be present, but you can see here under the new regs, it says you must allow parties to have others present. And so this sets up a potential dilemma. So if it's a Title IX investigation, you're going to have to allow others to be present. You're going to change the rules. But if it's just your standard assault at school, your default rule may be that others are not going to be present. So that you can see why it's causing a problem, because it's setting up two potentially very different systems. So we're going to have to look at these new regs and decide how are we going to blend these together, and how are we going to make sure we're treating people equally.
Wait, and how do you separate out the interview process, the ability to present evidence in Title IX compared to the student discipline aspect of this? And we'll talk about that in a second, but you're not typically thinking about that as you work through the student discipline process, really until you get to the point where the parents might request a hearing and threaten to bring a lawyer to the hearing. So being able to weigh out, okay, this particular question actually goes to student discipline and not Title IX is going to be really, really difficult to do in real time.
I emphasize this for the rest of the semester. You don't have to follow these.
Sure. Okay. So yeah, good question. I don't know if somebody's asked it, or if we just should have clarified it better, but these are not formal yet, right? These regulations, there have been comments that have been submitted for this school year, for the rest of this semester. All this green stuff doesn't apply unless to the extent we talk about that, it doesn't represent a change, right? So that's why we've done the text in black, text in green. We're pointing this out more, I think, in sort of preparation, because if we need to start firing live bullets come August, like if they put these regs into effect at the start of the 1920 school year, we want to have gone through some of this. And as you're thinking about staffing this spring, I think you're going to have to keep it in mind. So this stuff is not in place now. If that's you've been sort of freaking out and saying to your superintendent who's like, you go attend, get in here. Understand that the stuff in black we've talked about, that applies, but this new stuff isn't. We don't know exactly when it's going to be put into effect.
We have another question. Please clarify, discipline from school can be handed out before school investigation is complete. This is muddy.
This is muddy is
That means
exactly
you're
right.
getting it.
Yeah, this all sounds like bad news. Good job, you're following along. So yeah, the fact of the matter is, trying to tie this into student discipline, and I've got a slide that literally lays them out side by side here in a second, which I think will go to that specific question. But trying to figure out that what we do in discipline is we say, all right, I did enough investigation to believe that he totally groped her on the bus. I looked at the video of the bus. You can see his arms going over the seat. I believe now, based on that, that I've got enough to give the notice document to the superintendent, from the principal to the SU, suspend that kid pending the expulsion, and then send the expulsion letter to the family. All that stuff happens with respect to when you made the decision, which you literally cannot make until at least 22, 23 days into the Title IX process. So yes, the Student Discipline Act essentially says do enough to be able to give the parents assurance that what you believe is true and that you can prove it at a hearing, but don't do so much that you actually delay the student discipline process longer than you have to. It is triggered on when the decision maker makes the decision to institute student discipline.
And that's, you hit on one of the main comments and complaints that was submitted during the comment period is these rules do not work for a state student discipline act. And they just don't, they don't go together. And so we are anxious to see how are they going to respond, or are they going to respond at all to that complaint, because they don't go together very cleanly.
Yeah. So yeah, if you're wondering how this works in student discipline, the short answer is we don't know. And we're hoping they're receptive to those comments that were submitted at the close of January to at least some deference to the state disciplinary process as not impacting compliance with the regs. But who knows if we'll get it? I mean, they typically don't change regs that have been in place for 30 years, very willy-nilly. So we'll see. Okay, so this is now back to the, all right, so we're under the current law again. No matter what law applies, this step applies. Reviewing the documents and other evidence. Taking steps to preserve digital evidence. That's going to be weird under the new regulations, to put it honestly. Conferring with your IT experts on things like maintenance of that, being able to allow either side to be able to see the evidence you have. And then, like Karen said, I mean, Urban Dictionary might very well become, in a very professional way, one of the hot links on your Chrome browser or whatever it is you have, because you might be putting in a lot of stuff that you see and now deciding, well, does that constitute a Title IX type of thing, like Netflix and chill? That would be a good example. And then the step 5, prepare a written summary of the investigation and take action. This is another point where, under the current Title IX process, and what you'll be using for at least hopefully the rest of this semester, this can coincide with the student discipline stuff. In other words, we can point to that student discipline stuff and say that some of that satisfies the obligation for a written summary and taking action. If you expel somebody who's a sexual assailant, right? If somebody who's sexually assaulting people gets expelled, we can point to that. We'll write it up, right? You'll have notes on it and all that, but we might not be doing all of the things that the new regs would require. So either way, though, some sort of written summary of what you found in the investigation, the action you took, is still required.
Second bullet point is black but not green.
Okay, yeah, good. Karen brings it. Not required to provide the written report to the parties currently. There is guidance. There's sort of the sentiment in the Title IX OCR enforcement stuff that you should give the complainant all of the details and information about what it is that you discovered and the action that you took. There, in a lot of these cases, especially for a K-12 school, FERPA and other student record implications of that are kind of tricky, but there is no written in law requirement that you provide that written report, which right now is more of an internal document, a justification document, so to speak. You have to give information to the complainant, but not that document which you prepared. That's one of the things that will change pretty specifically under the new regs. So we talked about a lot of this stuff. I'm going to try to tick through it quickly as we come up on 10 o'clock here. But before you issue the investigation report, you must provide all of the evidence you have, right? So it contemplates you do this big, huge investigation, conduct interviews, and now you've got this big pot of stuff. It's some mix of your notes, written student statements, written staff statements, written witness statements, things that you found, right? Maybe it's a screenshot of a tweet or a snap or something like that, and you've got it all in this big bucket. You've got to put that in electronic format, which the parties cannot download or manipulate, and send it to both of them, and give them 10 days to respond just to the evidence without your intellectual thoughts of what it might mean. They just get to, I think, help you decide credibility. Must allow the parties to respond prior to issuing a report, which means you really shouldn't start your report until day 11 or you probably have some sort of risk in there that it looks like you would predetermine without getting their responses what was credible. So then after that, after the 10 days, so let's assume we're on day 11 now, you've got to issue your written report where you have to summarize the evidence that you believe to be important. And that report then must be issued 10 days before the decision is made, with the opportunity for both parties to respond yet again. Question.
How do we preserve digital evidence if it's illegal to view it?
How do we preserve digital evidence if it's illegal to view it? So in other words, student walks in and says, my significant other sent me this nude picture. You know that your first response, number one, is going to be to call the police, right? I don't care what the new regulations say. We don't want the sort of situation that's developed in these cases like from Virginia and others where administrators have been prosecuted for possession. So we're just going to tell OCR that I don't care if somebody actually gave us that and this bundle of evidence would otherwise include a nude photo of a minor. That's not something we're going to include and put in there. Now, there might be a note or a document evidencing, hey, this is what I was presented. This is what it showed to me. But I don't think we're not going to start trading in. The craziness of this is not going to make us start trading in child pornography. We are not going to allow that to happen because there's too much at stake for the administrators as that are investigating. Okay, so these two things have to happen, right? So if you're thinking to yourself, that's at least 22 days into this process, you're exactly right. Then on day, what would it be, 21 or 22, is when I think you can issue the written decision. So I don't think most K-12 schools are going to hold an actual hearing, but you do have to allow question and answers back and forth. We're not exactly sure how that's going to extend the timeline for a decision, but at some point after all this stuff happens, that new decision maker is going to have to deduce to writing the decision that they've made. It must be issued to both parties simultaneously, which is different again than Karen pointed out. Right now, you don't have to do that. You might have to inform them of the decision, but not give all the underlying documentation and report. And that must include identification of the code of conduct section allegedly violated, description of the investigatory process, findings of facts. So where do we make credibility determinations as the decision maker? Conclusions of application of the policy to the facts, or the law to the facts, as I think we view it. The rationale for any sanctions or remedies, like I think if I do this, he'll quit the misconduct, which is one of your obligations, and any appeal process that's allowed, which makes it complicated again, because our Student Discipline Act contains an automatic appeal process, but you don't necessarily have to have an appeal process under the new Title IX regulation.
If you're saying to yourself, holy cow, this sounds like two legal documents, two legal briefs, the investigation and then the decision, sounds like lawyers wrote this and lawyers are expected to write it. I think you're right. And that's why we're still, like I say, we're exploring ways to get you the help you need, but it's going to be way more lawyerly than the student discipline stuff that you've got now.
Yeah, and it's when they put out new proposed regulations, they're required to include essentially what do we think the financial impact of this will be.
Yeah.
And they estimate for each new Title IX case, something like several dozen attorney hours, even if that attorney is just assisting the school in complying. So the federal government is literally saying, by putting out these regs, we concede that all of you are going to have to call somebody like Karen, Steve, Bobby, Cody, Mandy, or your school's lawyer to help you with this process for dozens of hours at a time, right? They're actually contemplating that very thing. Okay, this I put up here, and I think this is the last slide that I've got in my part of this presentation. We'll take a quick break. But again, this just lays out some of the concepts in terms of lining up side by side the Student Discipline Act and some of its general timelines with these new Title IX regulations. It goes to the several questions we've gotten about how do you possibly reconcile these. I don't know that you can. So we talked about the day the decision is made, which is in most cases the day of the incident if it's something like a sexual assault. The principal has to send a letter to the superintendent. That's the one that allows you to kick to say that the student needs to be suspended immediately. Within 2 school days then, you have to give the letter as the principal to the family. They get the 5 days to request a hearing. Once the hearing officer is appointed, within 2 school days of being appointed, they have to schedule it. And then the hearing has to be held within 5 school days of the request. The hearing officer, after the student discipline hearing, reports back to the superintendent, who's required to issue a decision to the family, who then has 7 more days to appeal to the board. It is possible, I think, under the student discipline law, that even if everybody takes the maximum amount of time for each step of the process, that within 25 days, possibly as few as 22, you could be done with the entirety of the student discipline process prior to getting that baby into actual court if the family wants to appeal again. Compare that to the Title IX regulation stuff that we just talked about on the right side. That says the day of the incident, you begin the investigation, right? You got to give them, even if you gather all the evidence on day one, you got to give them 10 days to respond. The investigator has to write a report, which we assume is going to take at least a day, give that to the families who then have 10 days to respond to that. And at some point in there, this I should have added, there's this concept of question and answer back and forth between both parties with the investigator and to each other, which Karen will talk about later, I think. And then there's some written decision by the decision maker who may be the superintendent. So you're talking about the Student Discipline Act potentially ending prior to the first really decision on what consequences are going to be implemented under the new regulation. So again, those aren't in effect yet. The Student Discipline Act obviously is, the Title IX stuff is. But again, this is more to affirm your frustration that I don't know how this stuff's going to line up. Anything for you two to add there? Okay, that's a new slide. So we'll post it if you want to like bring this as evidence to the superintendent that you're not crazy. I promise this is what they all said. So after the investigation, Karen hit on this. We're just going to not touch on it any more than to say there could be school-wide responses. This concept of we have this culture in our activity program of allowing hazing, bullying, goosing, credit carding, that sort of harassment. And it talks about things like making sure that you train staff, students, and parents on recognizing, reporting, and responding to these things to not have these sorts of instances occur. Follow up with the victim. Karen mentioned this. We'll talk more when we get into the sort of the victim response stuff you have to have throughout this process now, these interim measures before the crazy new system actually gets all the way through working. That could be things like making sure that you're referring students to the SAT team as necessary and anything else you think educationally appropriate. You also have follow-up obligations with the aggressor. That's current. I mean, that is in place now. This notion that we're going to expel that kid and then that's the end of it isn't true under the Student Discipline Act. There's some interim education that happens, but Title IX would require you to ask what that student might need to stop the aggressive behavior, and that's it. So I think we're going to take a quick 5-minute break here. So we show 10:07, 10:06 here. Let's say that we'll come back and hopefully try to get started by about 12 after. Let's call it maybe 10:15 if you need to refill coffee too, and then we'll go with the next section.
go back and wait for Deb.
What was that? Oh. I'm in the middle of this.
Give him one more minute.
Yeah.
We're giving you a 1-minute warning and we'll get started again.
Great.
Clicker. All right. Well, for those of you that are freaking out a little bit, congratulations. I think you do understand it. You're getting the same response that we had after the first time we heard about the regs and read those. You can see things don't fit together perfectly. That's why they solicit comments. And hopefully we'll have some changes that'll come out that will give us better guidance. But again, the green stuff is proposed. It's not the rules yet, but they could be the rules at any point starting today. So. All right, we're going to go through a series of scenarios here and visit about some case law. Scenario one is the sex assault. You're the high school principal. Cindy comes to you and reports that Dylan grabbed her in the parking lot last night after practice. According to Cindy, Dylan dragged her into his car and forced her to perform fellatio on him. So that's the scenario we're looking at. What should you do? How should you investigate this? Number one, reporting sex assaults to law enforcement. I hope you all know there is a state statute that says the principal or their designee, basically when you're aware of a violation of the Student Discipline Act that also is a violation of the Nebraska Criminal Code, you're required to contact law enforcement. This is the one that sometimes upsets OCR. They don't like that we have to contact, especially on special ed students, but it's our law. We don't have a choice. If it's a law violation, we have to contact law enforcement. So step one is once you get this report, call the cops. But you still have to do your Title IX investigation, but don't tell the administration from Forest Hills that that's what you're supposed to do. In this case, we had a high school girl who alleged that a boy sexually assaulted her at school. And so this gets reported. Principal and the superintendent did a good job off the bat. They immediately contacted the school resource officer and contacted the sheriff and said, hey, we've gotten this report. Fantastic. So step one's checked off. They then look at the security footage, and this is where things kind of go off the rails because the girl, Jane Doe, had reported X, Y, and Z happened. They looked at the footage, and it didn't really follow what she had reported. So I think what we had is a case of the principal going, I'm not sure this is so true. And so he didn't do the best job of interviewing witnesses. He interviewed some, didn't record anything, didn't take any notes. That's not a good step. She apparently talked to her friends right after this. He didn't interview any of those people. He did not try to get a copy of the rape kit report. Did a lot of shoddy work in terms of his investigation. And so it just kind of sat there. Now there's a dispute. The school said, hey, the cops told us not to do our own separate investigation. And we get that report here a lot. And they say, hey, don't screw up our criminal case. Yeah, fantastic. We don't want to screw up your criminal case, but we also have Title IX obligations. And that includes interviewing and doing our own investigation to see if we have to take remedial measures or corrective measures. And so when a cop tells you that, you can't listen to that advice. You have to do your own investigation. So what the principal said is, I was told that, so I stopped. Plus, let's face it, they're the cops. They've got better resources. They're better trained. Their investigation is going to be better than ours anyway. So they kind of sat back and weren't doing a whole lot until 2 weeks later, there's a rumor that the same kid assaulted somebody else. Now they start to take it a little more seriously, both the cops and the school district. They put some interim measures in place, some remedial measures. They offered counseling for the girl and things like that. They finally removed that they were in classes together. They finally took the girl or the boy out of those classes, but that took 2 weeks. They still hadn't disciplined the kid. It took a month. They decided, okay, we're not going to let him play basketball anymore. And so they took him out of there. But really, they sat back. They put the remedial measures in place. But all of this harassment was occurring. She said his peers were harassing her. He was harassing her. Keyed the car, was blocking exits so she couldn't get by, was making noises at her in the hallways, stuff of that nature. The school basically did nothing in response to that, which was not a good thing. So we've got the assault, they did nothing. We have all this harassment that's occurring, they do nothing. They sat back and waited for the cops to do their investigation. It finally gets charged after the rumors come out that this other assault has occurred. And so he gets charged. At 7 months in, he finally pleads guilty. At that point, the school finally institutes discipline. They gave him a whole 5 days out of school suspension. That was it. And then 11 months after the assault occurred, they sent out a letter that says case closed. That was it. So it took them 11 months to close this case. Family obviously not happy. Sues, files a complaint and sues under Title IX. School says we weren't deliberately indifferent. Hey, we looked at the videotape. We contacted law enforcement. We got our counseling. We did all those other things. So we weren't deliberately indifferent. The problem is the court said, yeah, you took some steps, but then you just sat there. You didn't actually make a final decision. They said you admitted you were waiting for the cops to do their investigation and make their determination. And you really didn't do anything to the perpetrator until he pled guilty in court. And so the court said, you failed to interview friends. You waited months for someone else to make a conclusion. And he said, based on that, a jury easily could find that this was clearly unreasonable and represented deliberate indifference by the school. The key we want you to take away from this is you can't sit back and wait for the cops. You have to do your own investigation. And you have to have a timely conclusion. Waiting 11 months, waiting 7 months, that's not going to fly. As we said, they had that 60-day timeline flying around, not even close, and there was no legitimate reason to extend it out. And so we come back to this Q&A on sex assault that came out in September of 2017. The focus from them is going to be, is your response prompt and equitable? That's really what they're hammering on in these new regs too. They want to make sure that you've adopted and published this grievance procedure. And that was a discussion we had here yesterday. Do we really have to put all of these grievance procedure requirements that are in the new regs into writing, give them to people? I think the answer is yes. They're telling us we're going to have to, if we want the safe harbor protections. And we have to provide these prompt resolutions of the complaints. Here are the factors they're going to look at. Does it provide notice of the school's grievance procedure to everybody, students, parents, staff members? That's number one. Number two, do they apply the grievance procedures to complaints filed by students or on their behalf alleging sexual misconduct? So not only do we have them, are we actually using them? Do we have an adequate, reliable, and impartial investigation of the complaints, including an opportunity to present witnesses and other evidence? This is coming from some of those other cases that what was driving this. Hey, we didn't have a chance to defend ourselves. We had no due process. And the other part of that too is they want trained investigators. They have hammered on these people need training on pretty much everything as it relates to Title IX. Designates and follows a reasonably prompt time frame. So again, they're not saying 60 days, but that still is a good guidepost. But they do make clear, don't rush an investigation when there's good reason not to, but don't drag your heels when there's no good reason to do so. So notify the parties of the outcome of the complaint. That has to be in writing. Provides assurance that the school will take steps to prevent reoccurrence of sexual misconduct and to remedy its discriminatory effects. So again, make sure we're putting remedial measures in place, and make sure you follow up with both the victim and the perpetrator to make sure things are going as they should. So here's another green slide. This is some of the changes they're talking about. They want equitable treatment. And again, remember the driving force was those college cases where some of the accused were allegedly getting railroaded. And so we want equal treatment. So if you're going to do one thing for one side, you have to do the exact same thing for the other. They want notice of formal complaints to the respondent. They want that to be in writing. They want an objective. They want fair and unbiased people throughout this process. And as they talked about earlier, that's why they want different people doing each part of this investigation. They think if one person's doing it, you have a greater chance of bias in an unfair process. Unbiased administrative actors. They want the presumption of innocence. You cannot assume anything negative about either party based upon anything. They want a reasonably prompt resolution. We've talked about that. Description of potential sanctions, remedies, and available supports. They talk about this repeatedly in the new regs. You've got to it's all about notice. What could happen, what's available to me. And they also have a description of evidentiary standards that are going to be used as they talked about earlier. Are we going to use clear and convincing evidence as a standard? Are we going to use preponderance of the evidence as a standard? More changes. It would afford both parties the right to question the other party. Imagine how much fun that could be in a sexual assault case. It may be in written form in our schools, in the elementary and secondary context. It may be a live hearing. We're not required to have a live hearing. Universities and colleges will. Questioning would occur by advisors of each party, no personal confrontation. So they have taken into account, okay, it's a sexual assault case. We're not going to allow the perpetrator, alleged perpetrator, to question the victim and vice versa. We're not going to have this circus kind of thing. And they've actually said if they don't have an advisor during that portion of a hearing, you've got to find somebody. You've got to find a fair and impartial person to come in and ask questions on behalf of that person. They cannot ask those questions. So what about Cindy and Dylan? First, obviously, call the police. Second, conduct your own investigation. As we said here, it's just, they don't say in the regs that the Title IX coordinator can't do the investigation, but as we've seen, when you work through the process, we just don't see how it's possible that they could to meet all of their other requirements. Complete that investigation promptly. Again, try to shoot for that 60-day mark if you can. Take appropriate discipline with Dylan, but also, do you need to send him off to the student assistance team? What we've seen throughout the years is when these violent people, sexual or otherwise, do these things, they may be qualified for special ed and they've never been evaluated. It's never been considered. So you do have to take that into account. Do we also need to do that in addition to the stick? Do we have to give them a carrot? That kind of thing. Same as Cindy, we have to accommodate her. Does she need a referral to the student assistance team? What other services does she need? And you need to follow up with both of them to make sure that we're continuing to give them what they need. All right. How is the school protected if the student is found not guilty 6 months later? Great news. You're not held to the same standard as the criminal system. So even if you choose clear and convincing evidence as your standard, that's higher than typical. In criminal court, it's beyond a reasonable doubt, right? So it's very possible they can be found not guilty there, and they still are guilty. You know, that the allegations are true under your standards. Plus, sometimes you flat out get it wrong. Let's take the Doe case that we just looked at. Let's say they had said, nope, we don't think he did it because we looked at the videotape. It doesn't corroborate with what she alleged. So we're saying no. And then 7 months later, he pleads guilty. It happens. What the OCR is saying, you still have to have a fair and equitable procedure. It's just like a criminal court. They don't always get it right. I mean, OJ's walking around. So, you know, let's see. There seems to be a trend where schools are doing more than the police.
Yeah.
How does that play out in the hearing? Well, and sadly, I'm laughing because in a lot of our communities, you're right. And so how does that play out in a hearing? That's why they're having you do the investigations. That's why they want you to be trained. That's why they're hammering on these things, putting the police aside. Hey, if they gather evidence and they're willing to share it with us, you can and should use it. But this is why I think they're hammering on you need to be trained and you need to be fair and impartial, unbiased, and all those things, because you essentially need to act as a cop to some extent.
Punishment versus access.
What do you mean? Punishment. She's talking about punishment versus access. Criminal courts, it's after punishment. Under Title IX, this is all about access to education, right? And so we just need to make sure that everybody's getting the access to education that they're entitled to under Title IX. So there are two different approaches there. Can this unbiased investigator be from another school? This is one we kicked around and we thought, you know how when you have a student discipline hearing and you need a hearing officer and you call your neighbor and go, hey, I tell you what, you do this one for me and I'll do your next one. This is a possibility. You know, do they have proper training? Do they have all the things they need? But is this something that might come up? Yes. I mean, it's one of the things we have kicked around is to how are, especially our smaller schools, how are they going to be able to comply with all of these requirements?
One thing I want to drop in here just briefly as we talk about student discipline. Senator Vargas has introduced a bill which would actually make it more difficult to appoint hearing officers, how they have typically been appointed. This notion of when a school finds a hearing officer, there are more requirements for it. So it could be that the student discipline side is changing, which may inform this notion of you can't call your buddy who you know is in the bag for you, who's going to do what you want him to do or you want her to do. Somebody could raise that, and that's coming up in our student discipline context outside of Title IX, like literally as we speak. So I throw that out there.
All right, another question. I like to have a second administrator in a student investigation as a liability safety measure. And we typically recommend that you have two people there. Our district has only two administrators. Is this a Title IX conflict to use both administrators? No, but you're gonna have to hire more people. I mean, you're seeing the frustration and the difficulty that these new regulations are proposing. It's like we said, they have Chicago in mind. They have the University of Michigan in mind when they're saying, everybody's got all these people. They don't have, Central City, Nebraska in mind. That's not who they're thinking of when they're talking about these things. And so we are going to have to adapt. Number one, they're getting comments, so we're hoping they will adjust their regs. If they don't, we are going to have to adapt and figure out. I mean, we've talked about a teacher may have to play a role. You're going to have to get your best teacher to play one of these roles. So that's a very real possibility. Is there a list of people that are properly trained? No, not yet. But my guess is there will be if and when these regs pass. Under what circumstances does a parent need to be present, and what if they do not allow their child to be interviewed? Great question under these regs, because typically in a typical student discipline matter, they have no right to be present, and they have no right to say, you're not going to talk to my kid. Now we have these regs that say, hey, they get to have the advisor of their choice. That advisor could be their parent. And what if they say, you're not talking to my kid? I think they have that right under these regs. So you can see, again, there's an inherent conflict under what the law is in other contexts and what they're saying it is here. And so that is going to make things way more difficult. Oh, Jason Dolliver says, would somebody please share the new regs with the legislators that think schools spend too much money?
It's like, yeah, Jason, we'll send them. I see what you're saying.
We'll send them to the feds. We'll send them to the state. Yeah, and you're exactly right. I mean, you're putting this truly is putting an unfunded mandate on us. This is a lot of work. It's a lot of training, and you're just going to need more personnel to actually do it. So it's a good point. In light of the earlier information, if my elementary principal is Title IX coordinator for high school, can high school principal conduct the investigation? This comes back to yes, but you're still going to need, you've got that conflict with the student discipline, imposing the discipline, and we're going to have the same conflicts we've talked about. We simply, the way they've set it up, you simply need more bodies. And I don't know that we can give you a better answer at this point. Hopefully these proposed regs maybe will be a little different. All right, Ms. Hawsey.
As we're talking through, I keep in my mind thinking green slide versus black slide. Understand that your training, like if you're sitting here listening, I'm assuming you're a Title IX coordinator or somebody that's responsible for student discipline. All of the black stuff is what we have to do right now. So notice we still have obligations now. It's just that the proposed regulations are doing all the stupid who has to do what stuff. So we love those questions and I want to keep them coming, but I also, we're checking your box for current training, so I want to make sure that we also make clear that the black stuff is what you have to do right now. Okay, so number 2, English, you're the English teacher now. You're not the principal, you're not the superintendent, you're just an English teacher. Kim comes to you and says there's a group of senior girls who've watched the movie Mean Girls, and so they have their own burn book, and that they're using Snapchat for their burn book. They target Kim, and they call her fat, they call her slutty, they call her a bitch, and they call her ugly. Clearly, this is potentially bullying. Clearly, this is a student building culture problem. Question is this also a Title IX problem? And I think the answer is yes, yes, and yes. First thing I want to talk about, notice that this scenario says it's the English teacher. Is the English teacher now a responsible employee such that the fact that Kim has confided in the English teacher is enough to put the school district on the hook for deliberate indifference? The question and answer guidance from 2017, and again, remember I told you they've rescinded everything going back to 2001. So our best guidance right now is from 2001 that says any employee that has the authority to take action to solve the problem, and if a student reasonably believes that the employee has the authority to take that action, that makes you a responsible employee. So if this was the cook or the bus driver, bus driver's not great. Cook, probably the answer is no, not a responsible employee. But I think a student would reasonably assume that an English teacher has the authority to address this problem and is somebody in whom they should confide. So I think the English teacher currently is probably a responsible employee. For students. Now, if the student comes to the English teacher and confides that the social studies teacher made a pass at her, I don't think the English teacher right now is a responsible employee because the English teacher can't do anything to tell the social studies teacher to knock it off. So no matter who, if the allegation is student on student, I think all teachers currently are responsible employees. They have to report to the Title IX coordinator. And this means that when you do your back to school in-service or your next professional development day or your next what is it called, PLC, you need to be talking to staff members about, hey, remember, anybody that comes to you and talks about being bullied, if it includes any kind of sexual component, you have to run that up the chain of command to the Title IX coordinator. There are some exceptions for people that are licensed mental health practitioners who may be responsible employees for training purposes, but if the student has a legal expectation of confidentiality, then you wouldn't have to report it up the chain. That's going to be a small minority of you, but those of you that do have LMHPs in your building, they would be exceptions to the reporting obligation. Now, we got a green slide. Looky here. Any teacher, by the regulations say, literally any teacher in a K-12 context is automatically a responsible employee now. So if the teacher is a coach, and here's girls talking about in the locker room, once the teacher knows about it, the school district's obligation to investigate is triggered. That applies to student on student only, which I don't think is that much of a change. My question is this now going to expand to paraeducators and bus drivers and other people who would know students and have the ability to report the alleged sexual misconduct? The regulation defines sexual harassment as any unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies your access to the activity. So we're gonna have to train our staff now on when is getting called bitch once so severe, pervasive, and offensive that it affects your ability to be educated? Is getting called a bitch twice? is that when you put whore in, like there's a lot of fine line drawing that I'm not sure we've trained our staff, just the general teaching core, anything on how to make these determinations. This is a great case, 2018 case from New Mexico that really illustrates this line between what is so severe, pervasive, and objectively offensive that it triggers your Title IX obligation. So this is a cheer camp. There are two girls that film another girl in the shower against her will. We get calls like this, I don't know, twice a semester. The girl filming another girl in the shower or the bathroom is a real thing. And if your sponsors are not supervising the locker room, like standing there while the girls get naked and get in the shower, they should be. Because this is a thing that happens, it's an archetype now, it happens consistently. So in this case, the cheer coach, the girl who's filmed goes to the cheerleading coach and tells her what happened. And the cheer coach is just wildly inappropriate. Tells the girl that she's ruined the whole weekend for everybody, tells the girl to keep her mouth shut. When the girl then calls the police and the police show up to investigate the cheerleaders, cheer coach refuses to talk to the police, refuses to give access to the other members of the cheer team to the police, comes back to the school like a week later, forces the victim to stand up in front of the rest of the team and apologize to them for ruining their weekend. The cheer coach like won't let her do lifts anymore, makes her sit out for part of practices, eventually takes her off the varsity squad. Clearly an inappropriate response under Title IX. Then after the girl is kicked off the team, her teammates continue to harass her. They call her a slut, call her a whore and all of that. You can put the other stuff in that even Karen's afraid to say. Finally, the girl says, there are not many, but there are some. Finally, she says, hey, I can't stand it here anymore. I want to transfer. The district lets her transfer, and then she turns around and sues them under Title IX. Now, the court in this case said, this is a case where we're forced to draw those fine lines between what is bad and what is so severe, pervasive, and objectively offensive that no reasonable person should be expected to endure it. This case is that area. And the court said simply calling her names in this context was not enough to trigger Title IX obligation. And interestingly, a single incident of recording the girl in the shower was not enough. I'm not sure every court would agree with that. The question is, how offended is the judge when they are seeing the evidence of what happened, right? No, so severe or pervasive, no reasonable person should be expected to endure it. What is a reasonable person? Now, Bobby's right. I have no doubt that OCR would say your Title IX obligations are triggered and they would make you run the investigatory process. But the court here said that one video recording was not enough. What do you?
All right.
Wait, so let me just say, last bullet point. I think the first two bullet points are explained a little bit by the third one, because the court said, even though we're not going to find you liable under Title IX, we are going to find you liable for retaliation against her for reporting it. All the stuff the cheer coach did was retaliatory. And I think since the court knew they were going to hold the district liable on Claim B, that explains why they didn't hold them liable on Claim A. I'm not so sure that the outcome wouldn't be different if the court hadn't been confident they were going to tag the district on the back end for the retaliation. So, question.
Any advice for handling locker room or shower situations where we have girls coming forward saying they're uncomfortable knowing some girls are gay and they have to share a communal shower?
So you have girls who have have announced that they are gay or bi or tri or whatever I have many choices now I didn't even know I had when I was in high school. And so what happens then? I think that the answer to all of this is just good old-fashioned locker room supervision. The transgender cases would tell us that if a gender normative student says, I'm uncomfortable changing in a room with a transgendered student, and I think it would also be true for a gay student, that what you say to that girl is, you, the normative student, may go change someplace else. I do not think you can tell the gay student that she must change someplace else, although there's an argument in Nebraska law you could, but I think you're just playing with fire. But the courts have said that the normative student can be told that they can change someplace else. But the bottom line is we gotta have somebody in the locker room supervising. So that the worst thing that's happening is the gay students ogling the girl, but there's no touching, there's no harassing, there's no commenting, because there's a coach in the locker room to say, hey, knock that off.
And Brad Jacobson offers put up stalls and curtains, and I'd say a lot of our districts have done that. And I do a lot of construction work, and when the new construction comes up, this is one of the issues we do address. I think if somebody asked me 50 years from now, what's it going to look like? You're going to have all single stall restrooms is what you're going to have. And you're going to have partitions in all locker rooms, so it's complete privacy all the time. I think that's where we're headed. So I think people have started down that road, and quite frankly, I think that's going to be the answer as the law stands today.
When I was in high school, I remember so vividly walking into the locker room, and there was it was in Crete, there was like a single like pillar, and the water just came out the top, and everybody stood and showered like shoulder to shoulder. I just don't think new construction is going to put districts in the position of having to supervise in that kind of environment anymore. I agree with Steve-O. The way to do it is to build partitions or hang curtains.
I am assuming KSB would be willing to do some Title IX training for staff.
Yeah, yes, absolutely. And again, we're trying to figure out ways to make this plug and play, friendly, cost effective. So I don't know if that's going to be a video series. But seriously, when we send out the evaluation, I would love to hear your feedback about how you want it. I love coming to your buildings. Bobby loves coming to your buildings. Steve doesn't love teachers, but he loves coming to your
I love
buildings.
teachers. I'm not allowed to present to students.
That's
Apparently,
student.
I'm too honest.
Like
So,
all five of us would happily deploy and do training in person if that's what you want. Or is it better, this is what we're thinking, or is it better to have like a video series that they have to click through so you're not doing everybody, I don't know. But yeah, we're going to try to find some ways to do that for you in a cost-effective and user-friendly manner. Dennis Ship just texted me. He says, cha-ching. Hey, you can't blame us for what Betsy DeVos does. We're doing our best, my friend.
Oh, I'll blame Dennis.
we've got another one. Locker room supervision is not easy. In
I
many
know.
small schools, female activities are coached by only males.
I know.
Is it necessary to hire someone to supervise the locker room in that scenario?
Yes.
Yes, somebody has to be doing the supervision.
If you absolutely positively do not have a para or a certificated staff member who's the right gender to supervise the locker room, then you're going to have to either get a parent volunteer. I think it can be a parent. I don't think it has to be an employee. But I'm nervous about it being a parent volunteer if that parent's kid is the alleged sexual aggressor, right? But I do think it can be a volunteer. But no, guys, I love you all. I will defend you to the death. Just leaving locker rooms unsupervised because they're girls, that is in and of itself a Title IX violation. And that is the current state of play in way too many school districts across this state. We've had more locker room problems with girls in the last 5 years than boys. It used to be boys in the locker room. It's girls doing weird crap in the locker room that we get calls on now. So. This Krebs case. So this one, the school wins. Court says being called names is not bad enough. This is an 8th grade girl who we don't have a video in the shower. We don't have anything like that. We literally have them telling her, you're stupid, you're a slut, you're a whore. Somebody texted a picture of a bloody wrist with the letters KYS, which stands for kill yourself. At one point, the girl told the bullies to knock it off. She got into a fist fight and had somebody punch her in the face, and she had whatever this is, her eye socket fractured, their cheekbone, whatever this is. And the parents go to the principal and say, this is ridiculous. And I can hear my principal saying this. I've heard you guys, we've talked about this. Principal says to the student, I need you to document, write it down every time this is happening. I need you to make a journal of all of this that is happening. And then when the girl does it and presents all these incidents to the principal tells the parents, what do you want me to do? I can't be everywhere all the time. I can't stop it. And then this is an example of one of those dangerous words that Bobby talked about. He says to the parents, this is just something adolescent girls do. Girls are mean, which is true. You've heard me say probably, there is no creature in the world meaner than a middle school girl. It's true. But you can't say, and that's the state of play, so you have to suffer through it. Tragically, this little girl takes her own life, hangs herself in the family garage. Family sues the school saying that the failure to respond appropriately under Title IX creates liability for the girl's suicide. The court in this case says, this is enough. While infrequent name calling and bullying among adolescent peers may not rise to a Title IX violation, the constant and pervasive harassment with sex-based terms here does rise to Title IX. This is why anytime you have the Mean Girls Snapchat group, somebody getting called a slut and a whore, I would rather have you run it as a Title IX issue right now than not. Now, when we get to the green stuff and the Title IX investigation is way more formalized, I'm still not exactly sure how we're going to advise clients. But right now, while we're in the black slides, all of this I would treat as Title IX. There's no downside. The only thing really that you have to do extra is to go ahead and follow up with the victim after the investigation is done, like 6 weeks later, to see how she's doing and try to take affirmative steps to make sure the misconduct doesn't occur again. So coming back to our example, what about Kim? First off, you got to make dang sure that your English teacher knows that this is a mandatory report up to the Title IX coordinator. So you got to do that training. Secondly, I think you as the Title IX coordinator at this point in time can do your own investigation. Remember, under the proposed regulations, we have that insanity of we don't know who's going to do the investigation, but it can't be the Title IX coordinator. Even today, without the green, follow up and make sure that Kim does not struggle going forward and consider or continue to be harassed. Then I love referring the victim to a student assistance team. Even if the team says Kim's a straight A student, she's doing fine, she doesn't need help, that act of referring shows that you weren't deliberately indifferent. It shows that you were trying to address Kim's needs. So then the next question is, do we discipline the mean girls? And here the proposed regulations basically say, discipline is at your discretion. We're not going to second guess you, except we do expect that you take appropriate steps to restore the complainant's status to the same place she would be as if she had not been sexually harassed. And so I kind of see that as the DeVos Department of Ed talking out of both sides of their mouth. I would discipline the mean girls. Now, I don't think it has to be massive, right? It can be an in-school suspension, it can be a detention, it can be having to write a paper on bullying and cyberbullying. But I'm nervous that if you don't do anything to those girls, it's going to be seen as deliberately indifferent. This is just, they go on and say they trust school leaders that you have knowledge about the student body. Unless it's clearly unreasonable, they say they're not going to second guess you. Again, I'm a little bit nervous that they are going to second guess you because you can see how the rest of these regulations are going. Questions, Evo?
We have one. Track athletes do not all go to the locker room at the same
Yes,
time.
yes.
How do we supervise the locker room?
I don't know if you saw on one of Bobby's slides where it was like, you know, check out areas that are problematic. And we had in parentheses track team for this exact reason. We have a ton of problems with track athletes because they dress out in phases and then they go practice in phases and then they go to the locker room in phases. Guys, hear me. It is negligent not to have supervision in the locker room. Like, think of it this way. Would your shop teacher, would it cut any ice with you as the building principal if the shop teacher said, boss, I have to leave kids in the shop with the circular saw running because I have to go watch people in the classroom? You would be like, plan your lesson better. Supervision is your primary function. We're not going to have a kid cut off his hand. Plan your track practice better. That's all I can tell you. Either you're going to have to hire more assistant track coaches and someone's job is to make sure that they are always in the locker room, or you're going to have to tell your track coaches they got to plan practice better. I love coaches. That's a little bit lazy to say the sprinters are going to do this, the weight guys are going to do this, and I'm not going to have to even think about student supervision. We don't let any other educational professional do that. We should not let track coaches do that. I'm sorry, but I just think it's crazy for us. I'm going to have a hard time. We're going to have a hard time defending you based on the history that we have in this state because you know that track locker room is a problem area. You do.
Based on Mean Girls burn book case, how do you suggest a school investigate who started the burn book and employ Title IX?
Under the current regulations, if Kim goes to the English teacher tells the principal or the superintendent, whoever the Title IX coordinator is, I think your regular student discipline process can be the same as your Title IX process. So the principal interviews Kim, says who's doing it, interviews the other girls. You kind of know who runs around with who in your building. So you're going to have as you're sitting here listening to the mean girl story, you've got a list of suspects in your head just based on knowing the kids in your building. So you interview them. You ask anybody if they have screenshots. You ask Kim if she has screenshots. You talk to Kim's friends. It's the same as if you're investigating whether or not somebody has a jewel in the bathroom, right? You just follow your normal process. Now, under the green, it's going to be a little more formalized because we're going to have to think about how we protect the mean girls' rights. Honestly, I'm not even prepared to tell you exactly how you do it under the green right now. But I can start, in my mind, I can start thinking about how you would do it. And I think we're going to have to give you guys some maybe written processes or an FAQ to kind of guide you through this if the regs go through the way they're drafted. Is that it? Who's pantsing?
Pantsing. All right, this one actually led to somewhat of a disagreement here in the office. Somebody who hypothetically.
What? We disagree?
I may have hypothetically been a pantser and a pantsee in high school.
Calm down, Bobby.
Karen and I had very different ideas about this, I think. So you're a paraeducator. During first grade recess, a group of students thinks it's funny to run up behind a peer who's wearing sweatpants and pull them down, exposing the student's underwear. That's our scenario. First question, is the paraeducator a responsible employee? That's going to be the issue. In K-12 schools, reporting student-on-student harassment to any teacher at that school gives the school actual knowledge. I don't think a para is a teacher, so I don't think that's going to be sufficient to do actual knowledge. But for all schools, the test is whether the person who knows is an official with authority to take corrective action. This is where it would be interesting. A para certainly could tell a kid, go stand against the wall, right? Could a para suspend that kid? No. Could a para send that kid down to the principal? Probably. And so you can see under the new rules, they said this is going to be a case-by-case factual determination as to whether somebody is or is not a responsible employee. You can see how a para cuts both ways. I don't think they would be a responsible employee. I don't think they have enough authority to take the corrective action that they're talking about under Title IX. The safest approach would be to consider them a responsible employee and employ all the strategies that you have. So under state law, I think this cuts against the para. It says administrative and teaching personnel may take certain actions, and then they list those. I think you could give a para the authority to do that, but under state statute, they're not listed there. So that would cut against them being a responsible employee. The second question, is this behavior because of sex? This is really where we disagreed. In my pantsing situation, it truly was. Go back to this, the situation of sweatpants. That's how we determined who got pants. Were they wearing sweatpants? They got pants. That's just how it went. So if you were dumb enough to wear sweatpants, it happened to you. It had nothing to do with your gender. It had nothing to do with sexual arousal or any kind of sexual assault. That was it. And so we do have court cases that say you kind of sort of have to investigate. If the kid says, why'd you do it? He stole my lunch money yesterday. That's not because of sex. That's not on the basis of sex.
Now, just to make it one more step weird, because school lawyers are this way, when Steve says, well, you didn't get pants because you're a boy, you got pants because you're wearing sweatpants, I'm wearing sweatpants because I'm on the spectrum, and I can't stand anything with a buckle or a fastener. Now we've got potential disability-based discrimination. So the don't do that, don't wear sweatpants, it's not going to fly.
You know it's coming, even if you're on the spectrum. So anyway, I can say that because I'm on the spectrum. All right, age of the students is not determinative. We would likely advise you to investigate as a Title IX issue. That's really the issue. There would, on the one hand, be no downside of being investigating as a Title IX issue. On the other hand, you saw those new regs. Do you seriously want to have to jump through all those hoops? You have to give a written report here, wait 10 days. Give a written report over here, wait 10 days. Have a hearing. Because somebody got pants because they were wearing sweatpants? I don't think so, but again, that's the issue. You can see how we're coming up to those lines. Any questions on that?
You've got the phone, friend.
Let's see. Currently, we don't have a female PE teacher. Do we need to have a female para in the locker room during the changing tides? Somebody's got to be there. Somebody. A body has to be in there. Somebody of some level of responsibility. So, yes.
I think we're going to do a quick take 5 here because then we're going to truck through the rest of it fairly quickly. We're going to come back at 11 o'clock and start with the transgender hypothetical that we have. Want to make sure that everybody has a little bit of time to hit the restroom if you need to, refill on coffee, and we will be back shortly.
Oh my gosh, well, I was cleaning off papers, I'm looking over the I know, I'm sure I didn't, I wasn't blowing my nose. I mean, oh, Lord. See, I have mine all off that, I can only see. What's in this or what. So if I would have not have done that, I probably. But you're right, I just have to laugh.
To change clothes. 1 minute warning. We will be starting again in 1 minute.
you're in the locker room.
Okay, we're going to go ahead and get rolling again here on the transgender student hypothetical. And we've got an hour left to get through a lot of stuff, so we're going to move fairly quickly here. But this one is I'm sorry, we got a
We got a
question.
few questions here. How do you protect a coach from the accusation that he looked at me when I was getting in the shower?
So Karen is going to, never mind. She's going to, nope, okay. So I will tell you this, it frustrates all of us, Karen more so, because she's right when she says for 10 years she's been saying that is a cop-out. It's not that we don't understand the concept that you're going to be called a creeper, and there may even be somebody that posts on social media that the coach stared at me while I was in the shower. We get all of that. Here's what we're going to tell you is that you are listening to lawyers in a Title IX presentation who also have the, luxury of sitting in Lincoln and thinking about things like liability. The short answer is you should tell your parents at the beginning of the year that in Nebraska alone, we've had drumsticks, broom handles, and pop bottles used to sodomize students allegedly in school buildings or even outside of school. But as you know now, it's a Title IX issue. So you tell parents if this is going to talk to your kid about it, if it's going to make them uncomfortable, they're welcome not to shower here at the school. Now, a lot of kids don't shower anyway now, but to the extent even that they have to change, I think you just be honest and own it. We as the school are going to have somebody in that room. That person is generally going to be there supervising. They may have to look at the students from time to time to do proper supervision. That is how it's going to be. So I think then you tell your coaching staff, hey, if they're in that same presentation with parents, this is how it's going to be here. It may be a change from the past, but I do not think you can handle it any other way. I get it. I get the not wanting to look like the creeper. Kids are going to say bad and inappropriate stuff. But the fact of the matter is most courts say that school staff members, as it relates to harassment by students, need to get a thicker skin, and you have to supervise locker rooms. We can't change those things no matter how much we understand your position.
Sort of joking, sort of not. Are your chances of getting sued greater under Title IX or Section 504?
Oh, man. Are your chances of getting sued under Title IX or 504 greater? I think your chances of getting an actual federal court lawsuit are greater under 504. And I say that because I think your chances of getting an OCR complaint are greater under Title IX. That's because any attorney who practices in the area of education law typically knows that the standard of deliberate indifference, when the courts look at what it means for a school to be deliberately indifferent, like the case from New Mexico that Karen talked about, right? Judges, typically speaking, and the reason we see that standard articulated into these new regulations is that courts have been much less likely to find schools out of compliance or liable than OCR, because OCR is much more aggressive with its standard under Title IX. So I think you're more likely to get sued under 504 because, especially under the new Fry case, where you have to answer those questions about when it is a 504 issue versus an IDEA issue, for example, it's become clearer when a lawsuit can be sustained under 504 as compared to Title IX, where courts have generally been more deferential to the school as long as they can prove that they at least weren't deliberately indifferent. The legal standard to meet in Title IX is much higher than in 504, so I think that's probably true.
One last question on supervision. I have told my female assistant coach to just go in and make an appearance periodically until the locker room is cleared. Is that good enough?
I do not think that if you get sued because somebody gets harassed in there, that's going to be good enough, because going in and out implies that you know that you can have somebody in that locker room, right? If somebody just does spot checks or drop-ins, it's not that you don't have somebody in there, it's that you're saying they're not going to be in there all the time. Under a negligence theory, right, the question is, did you act reasonably? Was it reasonable to leave students unsupervised for blocks of time in a locker room? If you're sending somebody in to do spot checks, you're probably conceding that may not be reasonable on its face. So I don't like it necessarily. I understand where you're coming from. But yes, I think you're probably going to have to ask that person to be in there at least more often.
Before you answer this, because you can tie this in, what about bathrooms during passing periods?
So would you tell a classroom teacher, just leave the kids unsupervised? As long as you drop in once or twice in the hour, they'll be fine. You'd fire that teacher. So remember that the locker room is an extension of your program. It's just like a classroom. Now, bathroom during passing period, I think the expectation is for administrator or for teachers to be in the hallway during passing periods. You see who goes in there and who comes out. Students are not getting undressed and showering in the bathroom. They should be voiding and then coming out. And so I think that is a different supervisory issue because you've only got 3 minutes to pee and get out and get to your next class.
That's one of the things that people say to answer this question of, well, we don't want to pay a bunch of people to supervise the locker room all the time. Well, then you have to do other things in combination with more supervision, like limiting the amount of time, right? Okay, you got 4 minutes to get in and get out of this locker room. Right now, I'm locking the door 4 minutes from now. It's that idle dilly-dally time that we don't like, we just drop in on occasion, and that gives them the opportunity to do things that are violations of law or student code of conduct. So anyway, okay. Now on to the transgender student exam. So if you haven't figured it out, we have pretty strong feelings about locker room supervision. And so if you want the curse-laden version, call Karen. All right, so you are the assistant principal. Pat is a student who is biologically male, birth certificate at birth was male, but presents as a female, as a transgender female. A group of parents is threatening to sue you if you allow Pat to change in the female locker room, use the female facilities, claiming that, hold on a second, that would be sex harassment against my student that is not transgender, that's using the facility specifically designated for his or her biological sex. This, again, is not that hypothetical. We have cases like this coming up all the time in Nebraska. We told you 5 years ago, it's a matter of it's a matter of when and not if, and that's, I think, coming to fruition. But let's assume we're working on these facts. First, the Trump administration action Trump administration action on prior transgender guidance has kept the issue in the news because the Obama administration guidance that came out in May of 2016 said defer to, and that is a protected class. The Trump administration rescinded that, but didn't do a whole lot to make clear what the law was moving forward. So we'll talk about kind of what they have said since that. Anecdotally, like we talked about, more Nebraska schools are calling with these questions. It'd be interesting to do a survey to see now how many schools in Nebraska, as compared to not, have had a student notify them that they're consider themselves transgender. So the Office of Civil Rights and the Department of Justice issued that guidance we talked about. And then in 2017, the same time Trump administration was making the declarations with respect to Title IX generally, they are saying stuff like, well, that guidance letter essentially was the regulation by letter concept that we don't like. So they put out, in a non-ironic way, they put out a letter to withdraw the letter and said that essentially continued protection of all students is required. So we're not going to specifically target LGBTQ plus students or transgender students. We're going to say you've got an anti-harassment obligation for any student, which would apply if they're being bullied or targeted on the basis of their gender identity. And so they had internal guidance then that was leaked, so to speak, that came out, that was public. I don't think it was a mistake that it was more or less made public, where essentially I think they backed off even further this notion of this student says that their Title IX rights are violated because they can't use the bathroom or locker room as a transgender student consistent with that gender identity. I think internally they sort of looked like they were positioning off of investigating more of those independently. This is while lawsuits were continuing to trickle in with respect to the rights of transgender students under Title IX. So we'll get to that. So what they said is sex discrimination against transgender students will still be something that they will may open an investigation on. So it's not that they're saying transgender students have no protections. It's just that they're not going to take the position that the Obama administration had with respect to when they might open an investigation. Sex discrimination, sex harassment for transgender students is all still going to apply. And the same with this concept of hostile environment, a hostile educational environment, it's called in some of these claims. But essentially where they say, if it's based on sex or the sort of sex stereotypes that Karen was talking about in her example earlier, such as refusing to use a transgender student's preferred pronoun when you call Robert Bobby, or when you call Steven Steve. If I say, no, I'm Bobby, you're going to call me he. So all of this notion about if a school gets what seems like a reasonable request that they make for a cis normative for a student that is not transgender, you can't fail to make that same accommodation for a transgender student. So they started, I think, frankly, to look at it kind of how we were viewing it under the context of you should make accommodations when you'd otherwise make them for any student. And so I think they kind of took that position in their internal investigation guidance. And again, retaliation against a transgender student, all that stuff would still apply. So what they didn't say in the guidance is we're going to launch investigations purely on the school denied my ability to use the locker room and bathroom consistent with my gender identity. At the same time, the courts were coming down the opposite way, which we'll talk about in a second. So this is how OCR tries to parse through it, at least a couple of years ago in June, that it is entirely possible that if there's a whole laundry list of allegations from a student who identifies as transgender, some of those we will investigate and some of them we may not, even to the extent that our administration disagrees with the Obama administration on the application of Title IX to transgender students. So this is not a, hold on, we're not investigating any of these anymore, but we're going to parse it out on a case-by-case basis. And then getting, according to news reports, OCR has essentially closed a lot of these complaints that were focused solely on the issue of facility use. So OCR and DOJ, again, they withdrew that guidance in cases related to Title IX. The Department of Justice argued under the Trump administration, in fact, that sex does not include gender. So this was in the Title VII context, which is the employment sex discrimination law. That's where Title IX gets a lot of its guidance from as courts interpret it. So you have the Trump administration really following through, though, on this sort of step-by-step notion to back away from the concept that the term sex encompasses gender identity. The New York Times even reported, and we talked about this, I think we all probably tweeted about it, I don't think we posted, but there's an article that came out that said they were floating a memo internally between the White House and the DOJ and the Department of Education of actually coming out with a new reg, like the green ones we've been talking about, which says sex does not include gender identity. For political reasons, for whatever reasons they may be, they have not done that. But I don't think it was a mistake that they floated that memo was circulating. So it's some combination of we're kind of still in the feeling out phase, but we're really kind of moving away from this notion that we're conceding that Title IX includes gender identity. And again, putting us sort of in the state of flux that we were before the Obama administration guidance.
That is a classic election year press release. I don't think
Yeah.
that's gone away. I think they're just holding their fire.
Karen's probably right. She knows, if you couldn't hear, she knows that may be a political decision that they've made. Maybe they're now next year as the election heats up, they're going to start to roll out a little more of the rollback
Who do you
concept.
want, Elizabeth Warren or, gender normative Donald Trump? I think that's what's going to happen.
Yeah. So one thing we did want to point out is that all that OCR guidance and the national, I guess, attorneys and people that were talking about this saying, you should allow transgender students to do whatever they want, use the facility consistent with their gender identity and not think again about it. The Office of Civil Rights actually launched an investigation into a school that had followed the very guidance that that office had issued on the basis that allowing the transgender student without restriction to use the bathroom consistent with their gender identity may have created a hostile environment in and of itself. So that's the reason we say in the OCR is officially drunk, because they said in May of 2016, allow that transgender student to do whatever it is that they identify with and don't ask questions about it. Then after the rollbacks, the same OCR launched an investigation when there was a sexual assault in the bathroom by that transgender student. So back to our fact scenario, the parents that say, I'm worried about my kid in the bathroom with that student, this is like the nightmare scenario where that happened in this school. So OCR says, maybe you shouldn't have followed our advice 2 years ago and put that policy in place. So again, the inconsistencies continue to abound. It's an evolving area of the law. So where do we stand now? The recently proposed Title IX regulations, the stuff in green that we've been talking about, does not redefine sex. So the notion of whether sex as a term, as an umbrella term, encompasses or includes gender identity still has not been clarified, at least in regulations. Some of the guidance remains in place, the stuff that we talked about before this. They have had on a policy level, on a internal investigation and handling level. There's no doubt the Trump administration has moved away from some of those Obama positions. And again, we still have no definitive for schools in Nebraska legal determination on whether Title IX covers a student who is transgender. So we're going to talk briefly here about the various cases under transgender. I think Steve is up first. Okay, real quickly, general litigation trends. If you take nothing away, if you've been like, all right, you just frustrated me again, fair enough. Number one, transgender students are winning their lawsuits on both the Title IX and an Equal Protection Clause basis, which we'll talk about in the cases. Number two, opponents, this group of community members that says, we're going to sue you if you allow the transgender student to use that bathroom, are losing their Title IX, Equal Protection, and Invasion of Privacy lawsuits.
All right, before we get into those, couple of questions. Does the Title IX coordinator have to be a certified staff member, or can it be a classified staff member?
I don't think it has to be a certified staff member. The interplay between discipline and Title IX is going to require some certification type of questions. But in terms of the ability, yeah, I think under the Student Discipline Act right now, you could designate investigation requirements to somebody who doesn't hold a certificate. But when those areas of state law require accommodations, things like that, to be handled by a certificate holder, it's going to matter.
If you go up to the top of the deck where we have what the Title IX coordinator has to, like what their qualifications are, they have to have the ability to like speak into policy, to have supervision, to influence the programs. So I think like a high level business manager, but I don't think they have to be certificated, but I don't think it can be your para. I think they have to be higher up than that.
In regards to supervision, how would you handle an away game with an all-male coaching staff?
Get a parent volunteer.
Yep.
And have that lined up ahead of time.
Yep.
Have all the other parents informed that that's what's going to happen. Tell those parents they're welcome to take their kid with them if they don't like that. I'm going to say this, and I love you all. Stop looking for excuses. There are ways to do this that I think you can do lawfully, and it's about informing parents of how it's going to go.
We find a way to get the fucking picture of the seniors transported to away games so we can put that up with zip ties on the fence, because the parent group gets themselves organized to do that. If you truly don't have a female to supervise, have a sign-up sheet for the parents for every away game. Hey, you have parents provide meals on the way home. You provide meals for film study. This is just, if you're going to use parents, I think that's perfectly fine. You just add it to the list of things that you're asking parents to volunteer to do.
Have them comply with your volunteering policies. Make it a requirement. Again, to me, the whole thing is making sure everybody knows up front this is what you're going to do, so you avoid these questions of not looking creepy. Who do we have doing it for an all-male staff? Those are practical problems, not legal excuses.
Back to transgender. A transgender student, biologically a boy, appears as a female, wants to be referred to as a female name when announced at graduation. And graduation gowns are blue for boys and gold for girls. What to do?
Make all your graduation gowns one color.
Yes.
If you are willing to call Robert Bobby as I walk across the stage, I worry that even the Trump OCR would say you should call Jane John, if that is how John, as a transgender male, asks to be identified. How do you distinguish between being willing to, in every document you have and every decision you make, call Robert Bobby, but say, and there are actually cases where teachers have been fired and have unsuccessfully sued because they have failed to accommodate things as simple as names and pronouns. So if I'm your staff, if you're talking to your staff, you should point to some of those cases where those staff members have said, I don't believe in that, or it violates my religion, or it violates my something, and say, well, hey, there are teachers that have literally been fired and sanctioned by their state departments of education for not complying with these directives.
For your graduation ceremony, I know what you do. You all say to the kid, tell us what you want called when you go across the stage. My kids have two middle names. It's Anna Marie Hasse Weber. My kids both had to tell them whether they wanted the Hasse in there or not. And I wasn't offended. It was but because the onus was on the kid, right? Kid, you tell us what you want called. Since you do that with typically gendered students, I agree with Bobby. I think you have to do that with transgendered students. Now, if you're telling me that you literally have your bookkeeper pull the birth certificate for every single kid, and you read what's on the birth certificate, whether they like it or not, then you can call the transgendered kid Francis instead of Francine. But unless you do that for every single other kid, you're gonna have to go with what the family requests.
I think that's right. And here's the problem. If you polled the students, almost all of them, I bet, would say call him, call her, whatever they want. You're trying to avoid a parent community perception issue, which I understand. For the most part, it's not students who are raising these things, right? I mean, that's just the truth. So, yeah.
All right, athletic director, activities director is a Title IX coordinator, okay.
Yeah, I think so.
Yeah.
Yep. Again, the only, I think, interesting questions will be when it comes to the discipline part, what certificate does that person hold?
The AED assistant principal, we have to think about how that works, but I think it could work.
Yep.
If the student is 13 and their parent doesn't want them to be called their transgender name,
Yeah.
as the student is requested, what do we do?
The Office of Civil Rights out of Kansas City still has sort of a parent deference approach. The Office of Civil Rights out of Chicago says you ignore the parent request in favor of the student. We have no idea what the law is going to shake out on that issue, other than knowing, think about how it would happen if I came into you crying and said, listen, I hate the name Robert. I want to be, please call me Bobby. And my parents said, you will call him Robert when he's here. What would you do? Because I think the answer is you should do the same thing. At least that's what OCR has told us.
And trust us here, we don't call them Bobby or Robert. So the Adams case, this is actually an interesting case because it's one that actually had a trial. It's one of the few. All the others didn't make it through a trial. They're decided on paperwork before they ever get there. So what we had here was a high school senior. It was a plaintiff who was biologically female, identified as a male. The school had a longstanding policy that required students to use their sex-segregated facilities in line with their biological sex. The interesting twist to this is, this was in Florida. If you change your gender through whatever means in Florida, you can go and get a new birth certificate that changes your gender on the birth certificate. So Adams had been in the school system since the beginning of time, and so he was registered as a female and was not allowed to change that. Once you put it in the system, you can't change it. Whereas if somebody who had changed their gender since birth but hadn't attended the school and then registered, well, then they had no problems recognizing that transgendered person. So it's kind of interesting how they would pick and choose how they were going to institute this. But anyway, this school actually did a fantastic job. They created these guidelines. They got this huge committee together. It had the school's attorney, it had teachers, parents, it had a whole bunch of people. And they went and visited other schools. They did a fantastic job of looking at how should we do this? What is the best way to do it? What is the legal way to do it? And so they created these guidelines to give access to these gender-neutral facilities. Students were not permitted access to boys' bathrooms, but was not required to use the girls' bathroom. In essence, they said, we've got these unisex bathrooms, so you can use the girls' restroom or you can use the unisex bathroom, but you're not going to the boys' bathroom. That's basically where they put the law down. It was interesting in the sense that in every other way you can imagine, they accommodated this kid. It just came down to the bathroom. They didn't have a locker room issue because Adams had no need to go in the locker room for any reason. But for all purposes other than the bathrooms, we didn't have an issue. They accommodated Adams. So they filed a civil rights lawsuit saying, hey, you violated the Equal Protection Clause and Title IX. Again, it went to trial. They had a 3-day trial in front of the judge. That was fascinating. If you're going to read one of these cases, I'd read this one. It's about 25 pages. They have all the psychological information at the beginning that really spells out all these terms and does a good job from a psychological perspective, saying this is where the issue is in the psychology world. So anyway, the bathroom policy, according to the court, was a sex-based classification subject to intermediate scrutiny. Won't bore you to death, but there's strict scrutiny, intermediate scrutiny, and then kind of a rational basis test. It's real low. So we're in the middle here. And so under this approach, they have to show its gender classification is substantially related to a sufficiently important government interest with an exceedingly persuasive justification. You can see that's kind of a high barrier the school has to meet. That's not too simple. And the school says, oh, we got it. We got concerns for safety and privacy, and those would withstand your intermediate scrutiny. And the court said, nah, we don't think so. And they said, well, what about their privacy? And they said, well, wait a minute. The evidence shows that, and this is why it was important they actually had a trial. Adams testified, when I go into the bathroom, I go into a stall, I close the door, I do my business, I come on out, I wash my hands, I leave. That's it. Nobody sees anything, and I don't see them. And so they said this privacy thing doesn't sell. And they said, besides, you've got gender normative kids, you've got cisgender kids, you've got gay kids. If they want to peek in the bathroom, they can peek. This isn't holding any water, so they weren't buying the privacy argument. So they turned to these Title IX claims. And they said you have to show it's discrimination in the educational program. Discrimination was on the basis of sex. The school board receives federal funding, and the discrimination caused the plaintiff harm. Really, we're looking at that second prong there. Was the discrimination on the basis of sex? And that's what all this litigation really is about, is just the term sex, whether it's Title IX, Title VII, or any of the other laws. When they say sex, does that include gender identity or any of these other related categories? So the issue was whether its exclusion was on the basis of sex. They said Title IX does not define sex. Neither does anything else for that matter. Noted that the OCR guidance had been rescinded. That was the guidance. One day they were saying, hey, it doesn't include it. Then they're saying, yes, it does. Then they repeal that. And now we're back to, well, we don't know where we are. So we turned to Title VII precedent, and they did find that sex included gender identity. And they look at gender norms. People have been discriminated against because they were female, but they presented more as male. And so they said, yeah, that is in an employment context protected by Title VII. This judge looked at those laws and those cases and said, yeah, we're going to find for Adams on the same basis. They gave him attorney fees. I tried to find out just to give you guys an idea of what kind of dollars we're talking, but I'm thinking given the amount of prep they did in a 3-day trial, it was a good number. Only $1,000 in damages, but you only need $1 so that you can get your attorney fees. And they gave him an injunction allowing access to the boys' restroom. This was not an overriding injunction that applied to everybody. They limited it only to Adams because that was the only evidence that was presented to the judge. Bobby? Go.
I'm up. So this is the case out of Wisconsin, Whitaker versus Kenosha. If you've been a part of any Title IX discussion on transgender before, you've probably talked about this case since 2017. But this is a student who I was female at birth, transitioned in 8th grade through their junior year when the lawsuit was filed to being representing as male. Had some really interesting related health issues, which I think makes this case seem a lot clearer when you just look at the holding of it. But I think this stuff is important. So this was a condition that essentially rendered the student capable of fainting if he was dehydrated. So one of the solutions, and so he was eventually diagnosed with gender dysphoria because the marked incongruence between his biological sex and his represented gender, began hormone therapy, actually went through all the process to change his name and all of that between 8th grade and junior year. The school had a position that he could not use the bathroom consistent with his gender identity, so he stopped drinking water. Now, I'm not saying it was a part of the litigation strategy, but if he got dehydrated, he would pass out. So it became necessary by doctor's order for him to both drink more water and use the restroom more regularly. So I think it forced the issue whether he intended it or not. So for his junior year, he just decides, I'm going to start using the boys' bathroom, and that actually happens for 6 months. A teacher eventually reports it to the principal, who meets with the kid, who says, hey, you can't use the boys' bathroom, you need to use the girls' bathroom, because on your birth certificate still it says that you are a girl. So the school directed Ash to use either the gender-neutral bathroom or the girls' bathroom, which again, strangely, OCR has accepted that as a solution in some of these cases, but the court in this case very specifically says, no, that's not good enough. So despite the school's directive, the student continues using the boys' bathroom uninterrupted for the remainder of the year, which begged the question to the court of how seriously they actually felt about the policy. And it could be, I'm reading the tea leaves here a little bit, but it could be that the school board and felt pressure maybe to put a policy in place that said do X, Y, or Z. And the administrators thought, well, if we enforce it that way, we're going to get sued. So I don't know exactly what happened, but either way, he uses the bathroom. But because he's repeatedly told, you shouldn't do that, he develops suicidal ideations and eventually files a lawsuit under Title IX and the Equal Protection Clause in the Constitution, which says essentially that you must treat similarly situated people the right way. And that becomes significant as we think about like the graduation issue, the name, pronoun issue, because it stops looking necessarily at whether Title IX includes gender identity and looks at whether similarly situated people are treated the same way. So he says, number one, you denied access to your facilities. Number two, you didn't use the pronoun and name that I asked you to use. Number three, you required a separate bathroom for me, and including separate bathrooms and rooms on trips if we took field trips. There was an allegation in the case, which unfortunately was not documented very well by the school, that the administrators had at some point considered requiring any transgender student to wear a bright green wristband so they could track where they were going to the bathroom more regularly. And they didn't allow him to run for prom king. So those are the things that Whitaker alleges in the case. So the opinion says, basically, Ash is a 17-year-old that made a simple request to use the boys' restroom while at school. And so then when that's how the opinion starts, you know how it's going to shake out. So the Seventh Circuit says, hey, to the extent that that lower court allowed Ash to use the bathroom that he wanted for his senior year, we completely agree. A policy that requires an individual to use a bathroom that does not conform to his or her gender identity at the time they ask or make the request violates Title IX and the Equal Protection Clause. Now, the Seventh Circuit does not apply to Nebraska. We still do not yet have a case from the Eighth Circuit stating this as clearly. But understand the Seventh Circuit, Sixth Circuit, Third Circuit, Fourth Circuit, the case that Steve was talking about out of Florida, they're all going the way of upholding the students' claims with respect to Title IX and equal protection and transgender. So they sent the case back down and said, yep, student, I think unless school you have any better arguments, you're going to use the bathroom that you want. In January, they got to this issue of attorney's fees that Steve was talking about. There was an $800,000 settlement paid probably by some combination of the school and the school's insurance carrier. The student got $150,000, the student's lawyer, $650,000 in attorney's fees. That's a lot of money, and that is obviously not something, I mean, they only really got to the phase of the student arguing that I should get to use the bathroom. They didn't go to what we call summary judgment. They didn't go to a trial. That's just to get the court, or get the case in front of a judge to answer the question of, should the school be stopped from enforcing this policy? Should we allow Ash to use the bathroom that he wants? That alone was an $800,000 settlement. The student's attorney was interviewed and in a news report said, this should send a clear message to all school districts that discriminating against transgender students is against the law. So again, it's a matter of time. We'll have a case in the 8th Circuit. So far, we don't, but the cases by and large are going that way.
All right, we're going to talk about a case out of Indiana, JAW. What we had here, this was very similar to the Adams case that I just talked about, but this was a preliminary injunction case. I brought my paper because I wanted to quote the court. You tell me how this turned out. At the hearings, he looked and sounded like a teenage boy. He is very unlikely to be mistaken for a girl at this point. Uh-oh. School's in trouble. And so what we had here is a biological girl identifying as a boy, started using the boys' restroom without asking or telling during the PE period. Parents, it wasn't the kids that were upset, which is often the case in many of these instances. Parents of 2 boys complained of the girls using the boys' restroom. The school told the students not to use the boys' restroom, provided access to a separate room, which actually was an unused girls' locker room. So they were, obviously, the JAW was rather offended by that. JAW attended classes in 2 buildings. They said use the girls' restrooms or use the nurse's office, which had the unisex bathroom. They were required to obtain permission to go to the nurse's bathroom. A lot of times when they went there, it was locked. And you see this, this is a theme throughout all these cases. They stop drinking. They don't want to take any liquids in because they're afraid to go to the bathroom. It's embarrassing. Either my choice is I have to go to this unisex bathroom and everybody knows why I'm going there, or I have to use the wrong bathroom. And so they're not too excited about that. So they relied on Whitaker, and the council sent her attorney or the boys' attorney sent a request to the school. Says, hey, let them use the boys' restroom. You better read this Whitaker case. And the school said, now that case is totally different. Doesn't apply to us. So JAW sued, went for an injunction. The court applied Whitaker, found that JAW was likely to win both on Title IX and the equal protection claims. Rejected the school's argument that the circumstances were distinguishable. They said, no, it's pretty much the same case. That's not going to fly.
So the next case, so you can see how these are going, right? That's a series of cases where the transgender student and their family win their lawsuit. So you've got Whitaker, you've got JAW, you've got the Adams case. There are several others. A string cite at this point would be very long. This is a case where a group of families in one of these circuits that has decided a case in favor of the transgender family made all the same arguments on the opposite side. So you have the students who are cisgender, the students that are, their gender identifies consistent with their biological sex. The boys saying to the school, we want to use the boys' restroom facility locker rooms without any biological females in there. So in other words, your policy of allowing transgender students to use the facilities consistent with their gender identity discriminates against us, the boys that want to use that facility without them in there. So initially, the court goes through and does a thorough analysis of basically what they say is, it is not possible to understand these cases until you first understand the definitions. And so the court, again, one of these cases, you know exactly how they're going to go. They start referring to the typically developing non-transgender boys as cisgender, which is the term that's kind of been assigned to somebody whose gender is consistent with their biological sex. So the court throughout says this group of cisgender high school students brings a lawsuit to ask us not to allow their classmate who is transgender to use the same facility. And the long and short of it is, they tried all the same arguments and tactics. They stopped drinking water, saying that we don't want to use the facility. They said it stigmatizes against us to have to go to the nurse's bathroom when you don't require the transgender student to do that. So they literally use Title IX, equal protection, invasion of privacy, all these rights that courts are using to say the transgender student wins. They're making those arguments on the opposite side, using the same, setting up the same facts as we just talked about in Whitaker, Adams, and JAW. So the district court in this case, the lower court says, nah, I'm sorry, students, you don't win. It goes up to the Third Circuit who says, yeah, as to your constitutional right of privacy, sorry, we don't buy it. The school is justified in invading anybody's privacy as long as they're proving that their basis for doing it is to avoid discrimination. So if the school is going to get sued by the transgender student, they can force you into that discomfort. I don't care how it makes you feel, if their purpose is to avoid discrimination, which again, based on those cases, is what they were doing. As to your claims that your Title IX rights should be protected, the students failed to show any hostile environment. That biologically female transgender male student using the bathroom or locker room with you, you've failed to provide any proof other than your discomfort as to how that's created some sort of hostile environment. So if you have not been discriminated against on the basis of your sex, then it's not something that this court can support. So basically the bottom line is the students and their parents who tried to use the exact same facts and the exact same arguments to the exact same court end up losing, which isn't a surprise. But we hear this question all the time from boards and administrators in Nebraska. What about the constituents in our community that say, I'm not sending my kid into that facility with that transgender student? And the short answer is, if the Eighth Circuit goes like all the other circuits that have decided the issue, tough. They're not going to win their argument. And if your reason for allowing the transgender student in is to avoid a discrimination claim from that person, then I think you've got the right to do that. Now, you should still handle all these, we think, on a case-by-case basis. You'll see that in a lot of these cases, the schools that get sued are the ones that make a definitive policy statement one way or another. I get the instinct to do that, but our position has been from the beginning that if these are truly Title IX claims, then they're by definition individualized. We shouldn't have you don't have a one-size-fits-all response for sexual assault victims. You shouldn't have one for all transgender students.
Run that analysis for the gay locker room.
Oh, okay, so Karen says, run the analysis for the student who says, or the students that say, I don't want to share a locker room facility with a gay student. So this is not a transgender student, right? These are all biologically male or female students, but one of their students says, I am gay. And so this notion of that person in my class who is also a male and I'm a male, it makes me uncomfortable because I know he is attracted to males, I think falls on the same sort of deaf ears in these courts. The fact of the matter is, if that person is walking up and saying sexually explicit things to his or her male classmates as the gay student, or if they're doing things to purposefully make them uncomfortable, then you should address the misconduct, not the sexual orientation status. That's what OCR says time and time again. If misconduct occurs, I don't care what the students identify as. If there's bullying, I don't care if it's on the basis of gender identity, weight, hair color, attractiveness, you're going to address it because it's bullying. It's the fact that we think we should have fundamentally different rules for gender identity and sexual orientation that typically gets schools in trouble.
All right, this poor school district in Illinois couldn't win for losing. This school district first gets an OCR filing against them by the transgender student saying, hey, you're not letting us use our bathrooms. And it's just like the other cases. They're putting them in the unisex bathrooms, or they're making them use the bathrooms of their biological sex. And so this school district settles with the transgender students and their parents, and they come to a resolution agreement with OCR. And it allows the transgender kids to use the facilities in conformance with their gender identity. So all is well, right? This is how all the other cases have gone. That's what we're doing. Well, no, of course not, because now the other parents jump in and say, parents of the cis gender kids, and say, hey, wait a minute, what about our rights? You're violating our privacy, all the things Bobby just talked about, the privacy, we're embarrassed and humiliated to have to address with these people, and yada, yada, all those things. And so they sue and say, you're violating our Title IX rights by making us hang out with the transgender students. And the district court said, no, there's federal protections against sex discrimination. They're substantially broader than those based on only sex genitalia or chromosomes. The students will suffer no irreparable harm. And again, just like Bobby said in the previous case, any student who fears their privacy would be impaired by encountering a transgender student in the bathroom or locker room simply has to access existing and available single-user facilities. So you can see how in all these cases, if all you had was single-user facilities, nobody has a complaint. And that's why I think we're going to end up there.
Yeah. So practically speaking, I think we've hit on most of this, but to Steve's point, courts are recognizing this notion that, oh, we'll just ask the transgender student to use a single sex or a non-described sex facility, the nurse's bathroom, the teacher bathroom in the hallway. Courts are saying, well, why don't you just make all the typical developers that are uncomfortable that the non-transgender students do the same thing? So it's obviously a game of chess, right? And as these cases get through the courts, that you can see where they're starting to align, and I think how it's going to go. So we talked about this. I think the best strategy is still to avoid making any sort of sweeping policy or procedural decisions. When a student comes in that says, I am transgender or I'm transitioning gender, the conversation with them should be very much individualized to their needs and where they are. I wouldn't just say, okay, give me the pronoun, give me the name, what bathrooms are you requesting, right? Because that's not how it's supposed to work. If that student said, I'm a victim of sex assault, they could have fundamentally different requests. And then work collaboratively with those students on their specific needs, knowing that eventually it is true that we can't make the decision for you. We can't make it for the board. But for the most part, I think an administrator making an informed decision at the time is the best defense, even if that decision is wrong in the eyes of one side or the other, versus a board stepping in and making a policy decision. So that's still our advice of how to handle situations like that where you get the requests.
All right, Bobby, how would transgender students and rooming in hotels for school activities work? Keep in mind limited rooms and budgeting for an extra room.
Well, so the Office of Civil Rights would say, unless you've got some sort of particularized fear, you should allow the transgender student to room with whomever, consistent with their gender identity, right?
And then if the cisgender student objects, they pay for their own room.
Yeah, that's right. And so Karen's point was, and if you have an objection from the parents of how the school's going to handle it, you can always give them the ability to pay for their own room out of their own pocket. I worry about the whole suite of issues. I worry about whether that parent's going to say nope under the Student Fees Act or something like that. They're going to have a good argument that the school should just buy 2 rooms. I mean, I get the limited budget thing, but in every context we talk to you about, we have a limited budget. That's not in the budget. It's not an adequate response.
I don't think buying 2 rooms is gonna work because remember the camping case where they put the.
Yeah, so Karen's right. I mean, this is what I'm saying. You can't win. There is no, this is how to handle it, because in cases where students have been told, no, we'll just get 2 rooms. That student has said, well, you only got 2 rooms because you think I'm transgender and that person thinks I'm creepy. So you've stigmatized the transgender student by buying the separate room in the first place. Again, there is no right answer, which is frustrating. We wish there was. We pride ourselves in helping you get to the answer that you want if we can. But for the most part, the answer here is, what does that student want? I think if you ask the student who was set up to bunk with them, hey, are you cool bunking with Steve, the biological female that's transgender? We can work it out so that obviously you don't have to be in there when any of the showering's happening. I think those students, I think the students are actually probably more okay with it than you think. That, again, that doesn't address the parent issue. But frankly, I'm not as worried about the parent issue as I am the reality of what you think is appropriate for that particular field trip.
Sports question. When a student identifies as a specific gender, does that require the individual to participate in sports for that gender only? In other words, no jumping back and forth. A girl that identifies as a boy wants to use the boys' restroom and do everything as a boy, has to play boys basketball and can't play girls basketball?
I believe that's what the NSAA's policy functionally says at this point. The lengths that one has to go through as a transgender student in Nebraska under the NSAA policy to be eligible to participate consistent with their gender identity, I don't know that, I'd have to go back and look at it. I don't know that it says once we agree that you are a transgender student who can participate, even if you're biologically male, as a female in female sports, because you've gone through our policy and what it requires. I don't know that it says that prevents you from going back and making a different decision later, but I think it implies that. And frankly, I don't know that somebody would go to the lengths that you need to satisfy that policy only to go back on it. So I think the short answer is, right, wrong, or indifferent with whatever the NSAA's policy says, you get to defer to that to some extent. The school is the one that helps students initiate that process, though. So if I was an administrator or an AD, I think my response would be, listen, the NSAA has a policy. We're not going to commit school resources to help you prove to them what you need to prove to them to be able to participate consistent with gender identity, but we'll certainly help you file that with them and start the process. Then it becomes an NSAA level decision. So I mean, that's how I would handle it. I don't know if that doesn't get to the root of it, shoot another text to Steve, but I think that's still the best response.
What is legally required to confirm a student is transgender? A doctor note or parent letter?
No. The fact of the matter is, unless you're talking about an actual gender dysphoria diagnosis or something like that, you're going to get a varied responses, even within the LGBTQ plus community, of what it means, what it takes. The school boards, the activity associations nationwide that have tried to say, all right, we need to see these 3 things, they're getting challenged on that. I think the short answer is, if you have a student who says, I'm transgender, Title IX says you meet with them and listen to their requests, no different than you would somebody else who says, I'm fearful that I'll be discriminated against.
Jason Dolliver said your question or your response made sense, so he clearly didn't listen to anything you said. Are private schools held to Title IX regs? Yes, if they receive federal funds.
We do work with several private schools, and the question is always, we need to track every dollar in, dollar out, even the pass-through stuff down through the state to figure it out.
Do students who identify as J-skers have any protection from discrimination? As far
No,
as I know,
no. And in fact, they should be eliminated from the state, period, if you're a J-sker. Sorry, Brad.
Sorry. Okay, so we've got 15 minutes to do creepy teachers. So we'll hit this one, kind of skim the surface, and I want to get to the like the last slide with the green sort of takeaways. And so if you've got summary questions that you want answered before we sign off at noon, start sending those via text message to Steve right now. So I'm going to hit this one real briefly, and then we'll answer text and do that. So you're the activities director. Ben comes to you and says the head track coach, Mrs. Smith, has been texting and Snapchatting him. Quick footnote, notice that we have a female teacher who is the sexual aggressor. That happens, I think that happens more this way right now than the other way. And administrators are still kind of surprised, like, whoa, this is a chick that's hitting on a high school boy. Yeah, that happens. At first, the communication was about track, but now it's starting to include Mrs. Smith's comments about Ben's appearance, and she's, thirsty and asking him if he finds her to be sexually attractive. What do you do? Obviously, you are going to take disciplinary action against Mrs. Smith. You're going to, I believe, put her on immediate administrative leave. You're going to investigate. In addition to the personnel issue, you've got a Title IX issue. The 2001 sexual harassment guidance, which is still good, made it clear that staff-on-student sexual relationships is sex harassment. In fact, the Davis case, which is the U.S. Supreme Court case on Title IX, was a teacher-student sexual relationship, interestingly, a lesbian relationship. So again, the idea that female teachers can't be sexually aggressive just isn't true. The guidance says that schools are responsible for taking prompt and effective action to stop the harassment and prevent its reoccurrence. That's easy, fire her. But look at the second sentence. You are also responsible for remedying the effects of the harassment on the student who is harassed. So again, you follow up with Ben. How you doing, buddy? You run him through the student assistance team if he's showing any kind of academic deficits or social deficits. Make sure that you don't forget that piece. I'm skipping this, although obviously you can't condition playing time or a grade on sexual favors. I know. Teacher on student sexual harassment, the question is, who can trigger liability for the district if you find out? I think in this scenario, the athletic director or activities director clearly is an official with the authority to institute corrective measures. If Ben had gone to another teacher or to a bus driver or a coach, I don't think they could necessarily impose liability on the district under the current rules. You have to have actual knowledge of harassment, and then if you're going to be liable, you have to have exhibited deliberate indifference. You don't care, you congratulate Mrs. Smith and give her a high five, or you turn the other way, or you just, it can't be true, Mrs. Smith would never do that. Those are all deliberate indifference responses. This is the kind of like my guiding principle in advising districts on these kind of sexually aggressive staff members. It's not the harassment itself that means that a family can sue you for Title IX violation. It's your response to the harassment that determines whether you're liable or not. So the fact that it happened is unfortunate, and we should stop it immediately, but that's not an automatic liability. The liability comes from how the AD responds when Ben comes to him. Now, one of the things that we talk about with staff members, and that I wanted to at least mention in a Title IX context, is the idea of adults grooming students. We think about grooming usually when it's pedophiles, like 50-year-old guy and 10-year-old kid gives a kid an iPod or iPhone and tells him not to tell the family. But one of the things that I want you to realize is increasingly we're seeing grooming taking place over social media with an adolescent or high school age student and the adult. I mean, it's not always like creepy guy with candy, right? The other thing about grooming is, and I see this over and over again, the predator also grooms the adults in the building or the community. When people say, oh my gosh, it couldn't be Mrs. Smith, she's just amazingly dedicated to kids, I want you to start asking yourself, is this someone who has like pulled the wool over your eyes and like very intentionally made it look like they're a better person than they really are to adults in the community, so that they would be held like to be above suspicion by the adults? That's one of the things as I have dug into the legal issues about adult predators. They don't just groom the victim, they also groom the parents of the victim and other adults in the context. So this is just the steps in the grooming process psychologically. I'll leave that to you just to have headlines. These are people from outside Nebraska, but we've had plenty of headlines in Nebraska.
Quick, talk about the principal failure to report in Omaha.
So in Omaha, there was a case of an elementary teacher who sexually assaulted students, and you've probably read some of the lurid stories in the Omaha World Herald. Was that yesterday or the day before? Just this week, the principal that was the building principal for that predator was arrested for failure to report suspected child abuse. Every single time we have a teacher-student relationship, even if you think it's consensual on the student's part, that is like the power imbalance makes it so it cannot be consensual. Always call the cops. If the police say there's nothing we're gonna do, if the police say we're gonna give Ben an award because Mrs. Smith is hot, I wanna kick that police officer in the groin, but we can't stop them from being good old boys, right? But we do report because that's the only way that we can protect your certificate and more importantly, protect you from criminal prosecution, which this principal from Omaha is now facing.
And in that case, if you remember, or if you read the story, it talks about the training that OPS did was really look at using the principal as an example to the rest of the staff, right? They changed their protocol and said essentially that the teachers had to report too.
Yeah.
And so if your school has not thought about in these cases, if the first report is from the teacher to the principal shall make the report, or the teachers can report themselves, if that's not clear to your staff,
yeah,
it shouldn't.
And teachers have an affirmative obligation to report as well. And the NSCA will tell teachers that they shouldn't just rely on the principal, they should also report. So I think everybody involved in these situations has a reporting obligation.
Yeah, in other words, it seems clear that I think some of those teachers probably failed to report too.
Yeah, yeah.
That's
And
that's long and short of it.
we'll see if they also get prosecuted. I won't be surprised if somebody doesn't.
Yeah.
Oh, so this is I think this cartoon is funny. Bobby thinks it's funny. Steve doesn't. That's because Steve is clearly not the funniest guy in the office. So this is just a case that says, oh God, this is one where the superintendent, they're getting sued for Title IX violations. Somebody's sleeping with a student. Superintendent says, oh, I never had training. I don't know who's trained us on Title IX. Dude, that's your job. It's your job to make sure your staff gets trained.
Don't say it, even if it's true.
I know. Every time I read this case, I have to laugh. And
We also had the board member on this one.
oh God, yeah.
The Curtis, the defendant in the criminal case, comes to a board member and goes, yeah, I had inappropriate sexual relations with that student. And the board member tells absolutely nobody.
Because Curtis is a successful coach and the board member wants to win state. I mean, that's, so yeah, this is just a cautionary tale. If anybody ever asks you, have you had Title IX training? The answer is always yes, yes. And so here the court said failure to train the staff in recognizing the warning signs of the sexually aggressive teacher was a violation of Title IX. Then the failure to investigate exacerbated it, but it was the failure to train that was the source of the initial liability. So I wanted to buzz through to leave about 5 minutes for general questions. I'm hoping that we did that, and then we'll have about 2 or 3 minutes with this summary slide that I've got next.
And we have a good one here. Before you close today, can you review the options for the 3 roles and what you would recommend for a district with a superintendent and 1 principal?
So Steve showed me your text and said, this is a really good question. Will you answer it? The problem right now is I'm not 100% sure what to tell you. The regulations are only proposed, right? So it's possible that they will tweak the regs to allow for the single or dual administrator buildings. So we're kind of waiting and hoping and praying for that, although I don't hold out a lot of hope. And then I told the guys, I just said yesterday, we need to get into our conference room with us and a beer and the regulations and a bunch of copies of our policies and the Student Discipline Act. And we just need to run those scenarios internally ourselves to figure out what the answer is. Because if you're saying, I don't know what the answer is, then you're understanding the problem. Because we don't 100% know what we're gonna advise either.
Here's what I would say, whether that's in the survey that we send out or just emailing us, if you as an administrator have thoughts practically about how you think it would be best that goes, we would love to consider those as we think through policy options. I mean, it is significant for us to know how administrators feel about this. So please, I don't know who asked the question or anybody else that's listening, send us thoughts, even if you're like, well, I don't know if this makes a lot of sense. Just send it and let us think about it, because it's important for us to do that.
I mean, as you've seen the proposed regs, the decision maker can't be the Title IX coordinator, can't be the investigator. And the Student Discipline Act says the decision maker is the principal. So we got to find two people on the administrative chain of command that are below the principal, because the regs also don't say that it has to flow up the chain of command, but it's pretty clear that that's what they're assuming.
Well,
it's implicit. So I think an assistant principal maybe could flip-flop in terms of how you work the system. But I don't think we can say the superintendent investigates and the principal's is the decision maker, because under the Student Discipline Act, then the superintendent is your next level up if you go to hearing on the suspension or expulsion.
And Steve talked about the slide, and I thought about jumping up then, but because I don't like to interrupt people, I decided not to. But instead, you have to have impartiality, basically. So somebody raised the point earlier. Bobby, if I have 2 days from the day I decide that kid should be expelled to get the notice from the principal to the superintendent and then from the principal to the family, haven't I sort of biased myself in saying what I believe the truth is within 2 days of the misconduct? And the short answer is yes, absolutely. And so that's why we talked ourselves into, you might need 4, potentially 5 different staff members, depending on how strictly they read those impartiality requirements.
And the other thing that I worry about, and I was going to jump up, but didn't want to interrupt Bobby because he's a
That's
baby.
never stopped.
That I think it's possible, that slide where you had the Student Discipline Act on one side and the new regs on the other, it's possible to say, well, you can't take any action under the Student Discipline Act until the 25th day has run for the Title IX investigation. But that can't be right, because that means the sexual assaulter is in the classroom next to her or his victim for, a month and a half. So I don't 100% know how we're going to do that.
Well, to add the last layer of it, and then we'll remind all of you that it was still in green. The Student Discipline Act allows you to discipline somebody who's been charged with sex assault, even off campus. So now you're going to add in the criminal component of that playing out, the deferring to law enforcement. What if we say he did, but the police says he didn't, or pleads it down, or vice versa? You're adding that in too, because our Student Discipline Act sort of begs the question of whether the school has to institute disciplinary consequences if a criminal charge actually happens.
So I think what we're probably going to land on internally is to emergency exclude the alleged sexually aggressive student while you run the Title IX investigation. And there's a specific portion of the notice of proposed rulemaking that I think would allow us to emergency exclude. That feels actually harsh to me, because now basically you're emergency excluding somebody for almost a month while you decide whether they did the bad thing or not. But I think that's where we're probably going to land in terms of discipline. But that doesn't answer the ultimate question, which is, we got a superintendent and principal. Where's our 2 other people? We don't know. It may be a guidance counselor. Maybe you can crisscross districts. Maybe you're going to have to hire somebody from the outside. We're still trying to figure out. We'd like to give you a list of possible solutions. We haven't figured them out yet.
If Johnny has detention and comes to practice 30 minutes late, can he dress alone unsupervised?
Probably. Would you let Johnny in the Honor Society storeroom where all the candy for the vending machine is stored? Would you trust Johnny not to steal? So here's my question. Ask yourself this: would we risk property loss or property damage under the same circumstances? I think that kind of sets us up on a negligence standard. So possibly, although if Johnny jumps off a bench and gives himself a concussion, we'll have to be able to defend leaving him alone, but at least he's not going to have a victim.
And I think it's just a general responsibility analysis. Who's Johnny? I mean, is Johnny a good kid? Is Johnny not a good kid?
Well, and this goes back a little bit to how you need to start thinking about this issue differently. Have the detention teacher, whether male or female, stand outside the locker room and say, Johnny, you got a minute.
Go.
Right? That there are solutions, I think, practically that OCR would beg you to put in place.
Can the investigator be outside the district, for example, an ESU person?
I believe so. That is a solution that we believe is going to be an option. We've been through the regs a bunch, but they've only been out since November, so we got to wait to be sure, but I think so. Yes.
One of the potential issues, I'm assuming that's from an ESU person or somebody thinking about, hey, can't our ESU just hire these people and shop them out? It's a good question,
Always
Ted.
thinking, Ted.
The ESU's potential liability in that is a really interesting thing to think through, because you have, I think, functionally undertaken some of those Title IX responsibilities. I think it's possible.
And you
but
also are a federal fund recipient, so.
there's some stuff we have to think through in terms of what that means for liability for the ESU if that person doesn't do it.
But we think so.
Can we assume you'll have a new policy this summer, assuming the regs are finalized? Yeah, absolutely.
I think if the regs are not finalized, we are very intentionally not going to touch the Title IX or the universal complaint procedure and discrimination stuff, because we're going to wait until the regs are finalized. But if they're finalized when our updates go out, we'll include it. And if they aren't, we'll have to send a freestanding update like we do sometimes.
And Brad Jacobson has pointed out, we've got Vargas's bill, LB 515. One, it has some hearing officer provisions in there that changes things on the student discipline side. But there's also a change in the timelines.
Exactly.
Yes.
And so those are going to interfere with the Title IX requirements as well. So we're going to have to measure those out and balance
And
this
that
out.
was so many questions on the comments were about student discipline that I'm assuming they're going to have to address that.
When I don't know, I have asked through the very limited connections I have that somebody put Vargas's bills, hopefully him, side by side with the Title IX regs, and at least maybe we can start the conversation. I don't know what's going to happen, but it'll be interesting to see if that bill goes, what it could mean moving forward.
Under the new regs, isn't the Title IX coordinator only the organizer of the investigation?
Starts to look more like that.
Yeah. And then the
They
question
provide
is,
some of the services
what
or set up
role,
the services.
what role can they play then as the investigation unfolds? And it looks to me like it's pretty limited.
I think that the primary function of that Title IX investigator as you get going is figuring out those interim measures that are necessary. So that's why I think a counselor could make some sense when that person has to decide, is there something as the investigation goes on that we need to put in place? But you run into weird
But under the-
certification issues.
Under the K-12 provision of the rules, it also says that the Title IX coordinator may be required in many instances to be the complainant, to file a complaint.
I don't know who asked this one, but I like it. Will KSB pay for my blood pressure pills?
We have excellent health insurance, no problem. So is anything else?
That's it.
Okay.
It's high noon, so if you got to split, you can launch the recording,
I
but
was
you
gonna
should
say,
cover this stuff.
I just want to hit this. This is just a summary of what we have seen, what we're thinking are the big changes coming under the proposed regulations. The return to the deliberate indifference standard is a positive change for schools. We could have done a whole 45-minute bird walk on what OCR was doing with their weird standard. Good news, one standard for OCR and the courts. That is a positive for schools. The whole thing about letting the person who has allegedly been victimized and the person accused of the sexual aggression, letting them ask each other questions. We're going to let a kindergartner cross-examine a third grader. That's going to be super weird. The regulations say in a K-12 context, the questions don't have to be made in person. It doesn't have to be face-to-face confrontation, but you do have to allow them to ask questions in writing if you don't allow face-to-face confrontation. So you can imagine crazy helicopter mom writing, isn't it true that in second grade you fondled yourself? I mean, it's going to be nuts. And we're going to have to think about exactly how we do it to get that right. And honestly, I don't know the answer yet. We do have more flexibility in how we respond to what the victim needs, but way less responsibility or flexibility in what the investigation itself looks like. And this question that we've had pop up over and over and over again this morning, how does this structure change if we can't have the decision maker and the Title IX coordinator do the investigation? It's going to completely change the structure and training that we're going to have to roll out. And we're working on it. But until the regs are finalized, I don't, even when the regs are finalized, it's going to take us some time to get our minds around it. But I do want you to have that seed planted that potentially big changes. I don't see there's any changes are coming. What exactly they are, we don't 100% know yet, but we can see what's in the horizon. What are you laughing at? That's it? Okay.
Shane asked there at the comment.
12:03, we will have the recording up hopefully yet today. I'll just go and cut it into iMovie yet this afternoon. If you have other questions, you can text them to Steve as the day goes on. We will see you soon.
Thank you. Thanks.
Bye, all y'all.